the IIP for inviting me as a faculty over here. Thank you everyone who is joining in this session. So today we will be delve into the compliances part under the IBBI. So I was thinking where to start with because we all are the compliance professionals and we are burdened with the compliance requirements by the different regulators, most important IBBI, IPA, and other regulators as well. So let us start this with the compliances under the CIRP regulations. Under the CIRP regulations, let me share you. Just a moment. Yes, this CIRP timeline, so that we could have the fair idea once again what is the compliances under the under the insolvency resolution process. Is it visible to everyone? Timeline?
No, it's not visible, sir.
Uh, just a second, please bear with me. I'm just sharing it. It is not visible. Vishwade.
इस वाले में है ना?
हाँ. Visible now, sir?
Yes, it's very much
Thank
visible.
you. Thank you, sir. Thank you. Yes, so under the insolvency and bankruptcy code, under the CIRP, when we have appointed as an IRP, immediately thereafter we have to start working. So the first and foremost requirement in this regard is publication of the public announcement, publication of the relevant form inviting claims from the public. That timeline is within the 3 days from the commencement of the CIRP. So this timeline is T plus 3 under regulation 6, sub regulation 1 of the relevant regulations, CRP regulations. Then there is another timeline that is T plus 14. T is your CIRP commencement date. So T plus 14, we have to had the claims received from different uh, creditors. Section 15(1)(c) is relevant here. Red Bill Regulation 6(2)(c) and 12(1). And this timeline starts from the appointment of the IRP. So within 14 days, we had to have the claim form received. Then next timeline is T plus 21. This is most relevant, most crucial, and most controversial timeline because we are not getting requisite documents and information for verification of the claim. So within 21 days from the commencement of the CIRP, IRP has to verify the claim under regulation 13, sub regulation 1. Requirement is there. Red with regulation 12(1). And this is so within 7 days of the receipt of the claim. Then moving forward, if the CD, corporate debtor, is in the business of real estate, then appointment of the AR is there. So the requirement of authorized representative, we also have to comply with. and the timeline is within 2 days from the verification of the claim. You must be aware that while publishing the Form A regarding the claim form, we have to give the name of AR for the home buyers or for the class of creditors, maybe deposit holders or so, the class of creditors. Those AR has to be selected by the creditors, and within 2 days after verification of the claim, application for appointment of the AR, the IRP has to submit before the adjudicating authority, and at the same time report certifying constitution of the committee of creditors also to be prepared and submit. And this T+30 is the last timeline for the IRP to hold the meeting of the committee of creditors under section 22 subsection 1 read with regulation 19(2). This is within 7 days of the report certifying constitution of the committee. So this 30 days timeline for the IRP is very important and very crucial, and we cannot take chance to deviate from this timeline, otherwise disciplinary actions may be initiated by the board. So after this 30 days, now coming to the appointment of the RP. So in the first meeting of the COC, the proposal for confirmation of the same IRP as a RP, or the COC may replace the IRP with another IP proposed by the COC. This timeline is T+30 as well. So after this, the appointment of the RP happens, and in some cases where the appointment cannot be made by the COC, then IRP has to perform the duties of the RP in the intervening period. So T+40 timeline has to be considered under regulation 17 sub-regulation 3. It's about the duty cast on the IRP to perform as the RP. T+47 regarding the valuers. Regulation 27 mandates regarding the appointment of the valuers, and within 7 days of the appointment of the RP, valuer has to be appointed, but valuer should not be appointed more than 47th day from the commencement of the CRP. So this T+47 timeline is prescribed. 12A with regulation 30A, this is regarding the withdrawal of the application of the withdrawal of the CRP, basically, where the COC desire that CRP has to be withdrawn based on some settlement or negotiations or whatever, then this withdrawal may be filed by the COC, and 90% approval by the majority of the COC is required. And this timeline is given, although this timeline is not adhered before the Honorable NCLT, because many times I have seen that this timeline is not followed, but still the timeline is here, W+10. Within 3 days of the approval of the COC, RP has to perform its part. RP has to file the applications, whatever. So this withdrawal related timeline is also given. Then regulation 35A. Regulation 35A prescribes about the timeline relating to the preferential, undervalued, and other transactions. So T plus 75 means within 75 days of the commencement of the CIRP, RP has to form the opinion whether there are transactions which are preferential or otherwise. So this opinion has to be formed within 75 days of the commencement of the CIRP. Then after forming the opinion, within 115 days from the CIRP commencement date, RP has to determine the quantum of the transactions. Then within 130 days, he is supposed to file the application before the Honorable NCLT for appropriate directions. So after 130 days, in between, there are certain other timelines which we have to follow under Regulation 36 and 36A. Regulation 36 provides that within 95 days of the commencement of the CIRP, information memorandum has to be submitted to the Committee of Creditors by the resolution professor. Then 36A prescribes about the EUI timelines, expression of interest, because in the CIRP, the main objective to get the corporate debtor resolved. So this is the broad timelines where RP has to publish Form G within 60 days from the commencement of the CIRP. After this, within 75 days of the commencement of the CIRP, EOI has to be submitted by the prospective resolution applicants, and RP is supposed to finalize the list of the prospective resolution applicants. The timeline would be T plus 85, means within 10 days from the last date of receipt of the expression of interest. If there are any objections on the list of the RAs, that is the provisional list, then objections in that regard may be submitted within next 5 days. So the timeline would be T plus 90. And after that, final list is supposed to be published or sent to the all members of the COC and the RAs, finalizing the names of the prospective resolution applicants, and the timeline is T plus 100. So in the first 100 days, it is required by the board that RP should complete this EUI related exercise and send the final list of the RA to the concerned person. Then in the next 5 days, that is from the issue of the final list, RFRP, request for resolution plan, has to be issued along with the evaluation matrix and information memorandum to all the RAs whose name have been finalized here. So the timeline would be T plus 105. Then under the CRP regulation, the 135th day, that is 30 days from the issue of the RFRP, resolution plan is supposed to be received by the RP. And in the next 20 days, 30 days, in 1 month, as soon as it is approved by the COC, the resolution plan has to be submitted before the adjudicating authority. And it is proposed that it has to be approved within 180 days. So this is the model timeline basically. This, all the IPs has to keep in mind and try to adhere each and every timeline, and there is no escape on the RP or the IRP to deviate or violate the timelines. So this is all the timelines which is required to be followed by the IP, and based on this process, certain other forms have been prescribed by the IBBI to monitor the performance of the IP. So this was the broad overview of the compliances part under the CIRP, and to make this compliance monitor by the board, forms have been prescribed. Now let us move to the other part of the today's session. That is the circular number 85 of 2025, which was issued on 26th May 2025. This circular is very, very important because on the basis of this circular, IBBI mandated every IRP to report the process through the electronic forms which have been prescribed. So let us go into the circular's detail. So the circular subject was the revised form under the CIRP. You must be remember, before this circular, there are certain forms that was the CIRP forms. So while we has to fill the CIRP forms, upload the CIRP form, there were the issues of duplication of data. The same information we are required to fill in different forms, and this was basically wastage of our time and resources. So IBBI, based on the discussions and the suggestions received by the IBBI has come out with the circulars and launched the revised forms under the CIRP regulations. So the IBBI by wide notification dated 19th May 2025, it has amended the regulation and simplified and streamlined certain or all the forms which were prescribed. The forms which were in existence, that were the CIRP forms, and these CIRP forms were 9 in numbers. There were 9 CIRP forms, where there were 9 CIRP forms, including one form, that is IP1. IP1 was there to add the assignment when we have given the consent and all, we have to add the assignment in IP1 form. Then after commencement of the CIRP, then CIRP 1 to 8 was there. So all these forms were consolidated, and 5 forms were notified at that point of time, and that is still there. So these CP1 to CP5 forms are there. We will go in these forms one by one. So the objective was to achieve the efficiency, the duplication of work or removing the duplications were the main object. Leveraging the technology was also introduced by the IBBI, because certain information which is already in the system, that is auto-populated in these forms while we fill in. This framework basically standardized the monthly reporting. Earlier, if we remember, that most of the forms were the event-based forms, but now these are basically the monthly forms except a few. So under the new framework, monthly reporting cycle has been introduced, and we are filing the forms now on monthly basis. In brief, let us see the forms. The CP1 form, which is in existence right now, that relates to the compliances from the commencement of the CIRP till the constitution of the committee of creditors. This CP1 form is required to be filed for that period. And this is required by whom? By the IRP. So the IRP will file CP1 form. And what is the cutoff date? The cutoff date of filing of this form is on or before the 10th day of the subsequent month. From where? From filing report on constitution of COC to adjudicating authority. It means the 30 days period. When the CRP commence and the RP file the report on constitution of the committee, T plus I think 23 is there timeline. Then this form, then the requirement for filing of this form arise. So this is from the commencement till the COC constitution. So what are the requirements? We will go into the details. So let us first understand what are the forms and what is the timeline and what is the event from where this timeline is counted. So in the CP1, that is the subsequent month of the constitution of the committee of creditors and filing of the report thereof. The next form which is prescribed is form CP2. In the CP2 form, this form is to be filed by the RP, and this form, filing of this form timeline is after the issuance of the RFRP. Once you issue the RFRP in the month, मान लीजिए आप you are issuing this form in the month of April, right? Then you have to file this form in the subsequent month, that is in the month of May, and that too before 10th of the May. So this is the requirement in terms of the timeline, and this form contains the data, or you have to fill the data from the constitution of the committee of creditors till the issue of the request for resolution plan, RFRP. So this will contain various data to monitor the timeline and performance of the RP by the board. Then next form is form CP3A. So under the CP3, there are two forms. One 3A and other is 3B. The 3A is required to be filed after filing of application with AA. And what is this application? This application may be approval of the resolution plan, the committee decision to liquidate the CD, or the closure of the insolvency process. So this form 3A is required when we as RP or IRP file this application for closure of the process. The closure may be by way of approval of the plan, rejection of the plan, liquidation, or whatever. And this form is also required to be filed in the subsequent month, and the date is before 10th of the subsequent month. Then CP3B. The form CP3B, this form has to be filed within 7 days of the order. Order of what? Order of approval of the plan or liquidation or closure. So whenever you file the application, this application adjudicate by the honorable bench, honorable adjudicating authority. Then once the order is passed, this CP3B form is required to be filed within 7 days of the disposal of the application. In some cases, the order passed and it is uploaded on the website of the NCLT, delayed. Then from the date of uploading, you can very well write what is the date of the order and what is the date of uploading of the order at the web portal of the NCLT. So this 3B form is required to be filed in this manner. So if you can see that CP1, CP2, CP3A, all these forms are required to be filed within on or before 10th day of the subsequent month, but this form 3B, CP3B is required to be filed within 7 days of the disposal of the applications. This you have to remember. It is not the monthly compliance. It is the compliance based on the passing of the application or order of the NCLT. Then we come to the CP4 form. Form number CP4, which is relating to the avoidance transactions reported to the adjudicating authority. The timeline of this CP4 is again on or before the 10th day of the subsequent month after filing of application with the adjudicating authority or disposal of the application by the AA. So this CP form may be filed on different occasions also. Multiple forms may be filed, this CP form. Because if you see the timeline, it is mentioned that after filing of the application with the AA or disposal of the applications by AA. It means after filing of the application, he has to file this CP form, and you also have to file this form CP4 when the application is disposed of. So all the avoidance transactions related compliances to be reported in form CP4. Then we come to the form number CP5. CP5 is a monthly form. On monthly basis, we have to report to the board through this form what the process, how the process is going on, and what is the progress, what is the delay, so everything is to be reported in this CP5 form. This form also required to be filed by the IRP or RP as the case may be, and that too before 10th of every month for the transactions or for the event or for the work of the preceding month, right? So everywhere in the timeline there are two major differences. One, in CP3B form, this form has to be filed within 7 days of the disposal of the application by the adjudicating authority, and CP5 form, that is the monthly form, and this will require to be filed on each and every month for the activities of the previous month. Now let us move to the next part of the circular. So every form which are prescribed that can be accessed by the login ID of the IP. The specific login credentials are there under the IBBI portal for the IP who is handling the assignments. So he has to report by logging into the IBBI portal, and that is the electronic platform. If you see the 9 number point of the circular, it directs that IP shall file the revised form through the electronic platforms. So when this circular was introduced, 3 events has been assumed. One, for the processes which will be commenced after 1st of June 2025. So if any process commences after 1st of June 2025, within timeline what is prescribed from CP1 to CP5, every IP has to ensure Then there was some transitional provision, which I will not go in detail. So that was just for the understanding. For the ongoing CRP, some relaxation was given to file the forms. So that time is over. I will not go into this. And for the closed CRP on or before 31st May 2025, at that point of time, so IP was required to submit the corresponding forms under the revised framework on or before 30th September 2025 at that point of time. So since the time is almost 1 year back, so we now have to concentrate only on CP1 to CP5. So if you see this point, all subsequent filings shall be made only through the new forms by the IP who is in office as IRP or RP. So if you remember or if you have heard that suppose you are replaced in some of the cases and the questions comes who will file the forms. So this point specifies that the IP who is in office as IRP or RP as on the last date of the month preceding the month in which the form is due to be filed. It means when I was the RP of some company in the month of April, say as on 30th April, I was RP and now I replaced. Then who has to file? Even though I am replaced now, but in the preceding month I was there, I was assuming the office as an IRP RP in the preceding month, I have to file the form. So there is no confusion at all that who will file the forms. So in case there is any difficulties in filing the form, IBBI has given the dedicated email ID, that is support.form@ibbi.gov.in, where you can email your difficulties, any technical issues or whatever. Then the IBBI will come out with the specific resolution of your problem. Now we will go the contents of the forms. It is, although I can go through the login ID, but login is very personal. So all the contents which are there in Annexure 1 as an indicative template, so all will be covered here. So just for the understanding, we can go in detail the content of the form CP1. So you remember we have just go through that CP1 is required to be filed when it is submitted within the 10th of the subsequent month or the succeeding month in which the report certifying COC is filed. So what are the contents? So this I can highlight. Report certifying constitution of the committee is filed. Then CP1 is required. So how it will be filed? There are certain columns. 4 columns are there on the top. When we file it, date of filing of report under regulation 17 sub-regulation 1. Here we have to specify when the date, what is the date of filing of the report. Then automatically the due date comes in the portal itself. It is auto-populated. Suppose you have filed the report of constitution of the committee on 15th of April 2026. Then due date would be 10th of May 2026. So for the April, the due date would be 10th of the succeeding month. So this will be auto-populated. It means you have to file this CP1 form within 10th of May 2026. If you are filing thereafter, then the delay, the number of days delay will also auto-populated there. And if it is the case, then you have to specify the reason why you are filing this form as delayed. So there is no chance of editing this form. Once you fill the date of filing of the report, the dates will automatically comes in. And if it is delayed, then you have to specify the reason of delay. Now let us go through what are the contents of the form CP1. I am going one by one. So first, you have to fill the details of the corporate debtor. So name of the corporate debtor auto-populated. SIN number auto-populated. PAN number auto-populated. Industry section auto-populated. So these details will automatically be been populated. Address. So 1 to 6 here, based on your assignment, this will automatically populated, and the details will be there. Then the additional details are also required to be given if you are knowing that is address of the principal office of the CD, address of the corporate office of the CD, registered email ID of the CD also auto populated, whether it is going concern or not. This you have to decide based on the informations you are having during the process. You have to decide and you have to check in whether this particular point is to be filled in as yes or no. Then whether any proceeding were pending against the CD under SICA, Sikh Industrial Companies Act, you also have to fill here yes or no. Then whether any proceeding for winding up initiated under the Companies Act, yes or no. Here you also have to fill, also have to check in. And then whether insolvency professionals details is also required to be here. Process email ID, as you know, for every process we have to create a new email ID. Then this email ID has to be filled in. Then part C is there. Part C deals with the admission of application by the AA. So here regarding the applications, you have to fill in. Application filed under section. So drop down is there. You have to attach the applications here. The details of the application like CP number, company petition number, date of filing. Sometimes this is very difficult for IPs to get the details of the particular applications. Then we must be aware that this requirement is to be filed after the filing of the constitution of the committee report through the CP1 form. Then we must approach the applicant, get the copy of the application which is filed before the NCLT with complete details of the filing and all. So what is the bench before which the application is filed? Then point number 5, name of the applicant, who are the applicants, whether it was the section 7, section 9, what is the applications. So here you have to specify each and everything regarding the applications in point number C. Then moving forward, date of the order appointing IRP. Amount of underlying default. Here you have to go through the application. You have to find out what is the default, what is the quantum of the default for which this application is admitted. So you have to fill in the amount of the default. And the date of the default you can only find out from either maybe from the order or from the application which is filed under relevant section. Then we have to file under point number D, the details of the public announcement. Under the details of the public announcement, what is the date of the public announcement? We have to fill in. Details of the publications, where we have published, in what newspaper, what is the edition of the newspaper, and date of the publication. So all the details regarding the publication we have to fill in this point number D. Then we have to also fill the date, last date of the submission of the claims as per the public announcement. Details of classes of creditors, if any, under section 21 6A, where the AR applies in particular CRP, then the details of the AR has to be filled in. And so under the details of the AR, first we have to fill number of class of creditors. So suppose in a company there is deposit holders as well as the home buyers. The number of class would be 2. So on the basis of number of the class, we have to fill the name of the IP for each class selected by the particular creditors of that class. So here we have to fill in the entire details of the AR. And under the point number E, process status, we have to fill whether the CD is listed as on the insolvency commencement date. We have to give the details in the form of yes or no. Has IRP taken into custody records and assets relating to CD? So here you can see there are 3 options. One is yes, then it's no, and then it's partial. So if as an IRP you are not able, or you were not able to take full custody of the records and assets of the CD, you can fill in the partial. If you could not take at all anything, then you have to select the no. So if no, whether application under section 92 has been filed or not. So you have to remember very careful here. If you are not getting any custody of the assets, whether have you filed any application under section 19(2) for directions to the suspended management for cooperation? And if it is not filed, then specify the reason why you have not filed the application despite you are not getting the custody of the records and assets. So this you have to file a report to the IBBI in the form this CP1. Then you have to fill in details of the creditors or the members of the COC. So here the tables may be added depending on the number of COC members. So if you can see here, the serial number, name, voting percentage, amount of admitted claims, and category are specified therein. So you have to simply punch in all the data relating to the committee of creditors. Then at last, in the CP1 form, the declaration is there. The IP has to declare that all the informations which are there in this form is correct to the, and so and so, so and so. Then it is to be filed under DSC or under e-sign. So sometimes DSC does not work, then we used to file it through e-sign. So this is the CP1 form. Any question about CP1 form we can take right now. Then we will move to the next form, that is CP2. Okay, so this is very easy form, I assume. Now coming to the form number CP2. So let me highlight this portion. Form number CP2. I have seen most of the IPs by himself fills this form, and some of the IP also take the help of their office staff to fill in this form. But my recommendation is that whatever form is going to be filled by the subordinate staff, it has to be thoroughly examined by the IP before final submission, because you are knowing each and everything of the process. The person who is filling the form may not be aware or may not be that much perfect in analyzing or understanding all each and every column of the particular form. So you must assist him or you must verify this form. So now coming to the form number CP2, and this CP2 form is required to be filed when the RFRP is issued. RFRP, if you remember, when this RFRP is a very important document, this is to be issued with the approval of the committee of creators. Based on this RFRP form, the resolution applicant or the prospective resolution applicants prepare his plan in conformity with all the provisions of the code as well as the regulations and submit the plan accordingly. So when you issue this RFRP, in which month, suppose you are issuing or you have issued the RFRP in the month of April, then the due date would be 10th of May of that particular year, and you have to file this form CP2 containing various details, because almost the first part of the process is completed. Why I'm saying the first part of the process? Because you have issued the RFRP and now the RA has to come in. RA has to submit the plan, prepare the plan, and the COC has to exercise its commercial wisdom, and then plan approval, then the role of the adjudicating authority. So the first part, after the first part is over, the second part is the issue of the RFRP. And the if you see the columns of this form, there are four dates, four columns are there. One, date of issue of the RFRP. Here you have to select on which date, on what date you have issued the RFRP. Then automatically the due date comes in. You cannot edit it. Then if you are filling this form delayed, then the delay number of days delayed is there and you have to specify the region. So this is almost common feature in all the CP forms to track the delay of number of days in filing of the particular form. Now let us move further to the contents of this form number CP2. The contents, one, about the CD. So about the CD, name, sin, this is auto-populated. Then the appointment of the registered valuers. The details will be filled in here by you. So whether registered valuer appointed, yes or no, you have to give in. If no, then reason. Then there is a table which will be filled in by punching the data of the valuers. Serial number 1, 2, 3, 4 will be there. Name of the valuer, their registration number, date of their appointment, and the class for which the valuer is appointed. So you must be knowing that there are three classes of assets under the insolvency process prescribed. That is land and building, plant and machinery, and securities and financial assets. At least two valuers under each of the class is required to be appointed. So here you have to fill in the data regarding the compliance of the appointment of the valuers. So after this, you have to give the details of the IM, information memorandum. Under this tab, you have to give the date of submission of the IM to the members of the committee of creditors. And here you have to specify whether this particular CD is MSME or not. Then details of the expression of interest and RFRP in detail you have to give. that date of issue of the provisional list, date of issue of the final list, date of EOI received, number of EOI received, number of decibel PRA, and last dates of submission of the plan. All this you have to give in under section C and D of this particular form. Now let us move to the next form, that is CP3A. So this CP3A, this is on the filing of the application. When we file applications for approval of the plan or liquidation or closure of the process, the due date would be auto-populated there. When you punch in the date of the filing of the application and e-filing number with bench and the court number. Very specific details is required to be filled in here under CP3A, so that IBBI could fetch up absolute data on the basis of the e-filing number and what is the NCLT bench and so on. So once you fill this data, due date would be automatically populated, and if you are filing in time, that delay will not displayed in terms of number of days. If you are filing late, then delay will be displayed and you have to give the reason. So after this, there are certain sections in this form, section 1, 2, 3, 4. So under section 1, the details of the CD will be auto-populated. You need not to do anything. Then drop down is there. Under the drop down, application for approval of the resolution plan. If the case is like this, if the case is for approval of the plan, you have to fill it. You have to select this from the drop down. Or application for initiation of the liquidation. If the cause of filing of this form is this particular, then you have to select this. Then 12A or dissolution or other. Please specify under the drop down. You have to select this one, then move forward. Now come to the section 2. So in the section 1, you have to select the particular cause why this form CP is getting filed. Under section 2, which deals with the details of the application for approval of the resolution plan field. So if your application was for the approval of the plan, you have to fill in name of the successful resolution applicant, date of meeting of the committee in which the resolution plan was approved, date of approval by of COC, when the voting is concluded. You must be remember that the date of meeting is different and the conclusion of date of voting is different. So here you have to mention the date when the voting on approval of the plan was concluded. Then percentage of voting share by which COC approved the resolution plan. Here the percentage you have to fill in, and then if any creditors, any of the creditors are dissenting, then you have to give the percentage of voting. Then section 3. Section 3 comes in when the application is for the initiation of liquidation process. So if the application is as such, you have to file and fill in the data. First, reason for filing application for liquidation of the CD. What is the reason for which, why are you filing? So there are certain reasons which is specified here, like no valuable assets, non-receipt of the resolution plan, rejection of the resolution plan by the COC, or any other reason. So for this, you have to refer regulation 40D. So drop-down options are there. Under the point number 2 of section 3, you have to mention or you have to select the date of the meeting when this liquidation is approved, then date of approval of the COC when the voting is concluded, and the percentage of voting by which this application approving for initiation of liquidation is passed. Then section 4. Section 4 regarding the 12A. So same data is required to be filed as in point number section 3, that is the reason of closure. What is the reason? So drop downs are there. Date when this application is filed by the RP for the withdrawal to the AA, and whether the application is filed before the COC constitution or it is after, if yes or if no. Then date of the meeting, you have to specify when the COC approved withdrawal and date of concluding of the voting. So this section 4 is to be filled in the given format. Then section 5, that is the common information filled in all three scenarios, but ABC, right? CP3. So this is the common information which is required. Details of interim finance, if you have availed or not, details to be given. Then if interim finance is there, then what is the rate? What is the amount availed? What is the amount sanctioned? So all the details regarding the interim finance, you have to fill in. Then declaration is there and this form will be filed. So this is all about the form CP3A. Now coming to the form CP3B, that is within 7 days, you must be remembering that this is within 7 days from the date of the order. So this CP3 form is more or less same. CP3A will contain the information of the application and CP3B will contain the information regarding the order. So the section 1 here, there different sections are given in 3B form also. So nature of the judicial order for completion of the process, select one. So there are four, there may be four options. One, approval of the resolution plan, liquidation withdrawal, or process set aside by the NCLT, or maybe other reason. So here you have to fill, then date of approval, then details of the claims admitted. Here you have to fill all the details, that is secured financial creditor, unsecured financial creditors, operational creditor, workmen, government. So all these claims you are required to be filled in. Then section 2 regarding resolution plan. If you have selected the approval of the resolution plan, then the details is to be filled in here. This is akin to the form H, information which is contained in form H. So if you see the form H of the CRP regulation, then these details you will find it. So details of the stakeholders claim and realization under resolution plan. So every column you have to fill in. So I'm going through the columns which are specified: serial number, category of stakeholder, number of creditors, amount claimed, amount admitted, and realization by the stakeholder. Amount and in terms of amount and in terms of percentage calculated. So IRP, insolvency resolution process cost, then secured financial creditors. So here, how many numbers are these SFCs? What is the amount claimed by them? What was the amount admitted? And what amount they are realizing, and what is the percentage of the total claim amount? So this percentage will be auto calculated according to the amount of the claim. After secured financial creditors, other than FC class, then financial creditors in a class. The same details for the financial creditors in class, for the for the unsecured financial creditors, you have to fill the how many are the unsecured FCs, what the amount of the claim they have made, what the amount of the claim admitted by the IRP, RP, and then what is the amount they are realizing and what is the percentage of their realization. Then for the OCs, operational creditors, same information is required for the government, workmen, employees, other debts and due, and shareholder. So basically 10 number of stakeholders or 10 category of stakeholders have been prescribed here under this form, and for each of the category of stakeholders you have to mention how they are in number, how many, then what is the amount they have claimed and their amount admitted and their realization. So if you can see under the star mark, if there are subcategories in category like real estate allottees, debenture holder, etc., please add rows. So you can add the rows in the particular category. If there are more than one person in that category, then subcategory may be created. Then amount, if any, proposed to be invested as part of the resolution plan, capex, working capital, etc. So this is all the information of the resolution plan, information derived from the resolution plan. Then you have to give whether RP is part of the implementing agency or monitoring committee, yes or no. If no, name of the other individual you have to give. Then whether RP made a determination of the preferential transactions or undervalued transactions. Here you have to fill in. If the data is there, then you have to specify who are the beneficiaries of that transactions in case it is decided in your favor, and what is the underlying amount therein. Then other details of resolution plan you have to give. So other details like infusion of equity, if it is there in the resolution plan, details of the bank guarantee, and name of the entity post resolution plan. So this all the information related to the resolution plan you have to give in this form 3B, CP3B. And if this is related to the liquidation, then the details of the liquidation you have to give. And in case of closure, then under section 4, the details of the order in respect of withdrawal or closure of the process you have to give in. Then section 5 is common section where you have to give the certain very important details, that is the average liquidation value and average fair value in this process, and the total CRP cost, which is further divided into two parts, process related cost and going concern related cost. So this is given in this form CP3B, and in this form CP3B you have to attach the documents like IM, RFRP, resolution plan, form H submitted to NCLT, order of the authority and the minutes of all the COC. So all these, like this is all the process documents where you will require to be submitted through this form 3B. And then declaration, then this form will be filed. Now we are coming to the form number CP4. So under this CP4 forms, this form is required to be filled in 10th of the on or before 10th of the succeeding month in which application for avoidance transaction is filed or the order in respect of such application is received or given by the adjudicating authority. So here you can see, as in the earlier forms, there are 4 columns: date of filing of the application, date of due date, then if delay, then the reason of delay. So these forms are common. So one thing you will notice here, that multiple submission of this form is allowed, as application may be filed on multiple dates. Different applications may be filed because there are certain sections, and this also allows modification of the column number 8 and 9 and 10 of this of the table given, which deals with the order. So this form is required to be filed when you file this application under preferential transactions, and again you have to file this form when the order is passed by the honorable adjudicating authority. So these 4 columns are almost same. Now we are moving forward for the other part of the contents of this form. Yes. So A, under the A section, IP detail is there. B section, CD details are there, and with the CD details, the details of the bench of the NCLT is also to be auto-populated here. Now, under C section, you have to specify the details of the avoidance applications filed during the CIRP. So, what details are required here? You can see the column heading itself, serial number, date of filing means when you filed the application, what is the filing number of that application, nature of applications, like whether it's a preferential transactions, which is specified under section 43 and 44, whether the transactions are undervalued transactions, covers under different sections 45, 46, 47, 48, 49, or the applications is related to the extortionate transactions covering section 50 and 51, or the fraudulent transactions under section 66, or the combination of the any of the. So the nature of transactions you have to specify here. Then you have to specify in this application, in this form itself, what is the relationship with CD of the particular party, rate party, if it is there. Then date of such transactions, then underlying value of the transactions, date of order. So this column number 8, 9 and 10, it can be modified based on the order of the NCLT. Then in this form, you can attach the order and the application as the case may be when you are filing this form. So this this form CP4 is specifically for the transactions or unavoidable transactions and specified under various sections. Then we are coming to the form number CP5. CP5 forms is filed 10th of every month. So basically, this is the progress report of your process, of your insolvency process, your RP or IRP. This form is required to be filed. So there are certain sections. Section number 1 is there, that is the general information section, where you have to fill the name of the IP. It is auto-populated, name of the CD, is SIN number or LLPI number, insolvency commencement date, filing for the year and filing for the month. Whether any exclusion period taken, yes or no. In the last month, you have to give in. Then period in number of days excluded by which authority, then you have to give in the details here. Serial number, start date, end date, number of days, other upload. So this all you have to give. Extension taken or not. Exclusion, regarding extension exclusion, this is the appropriate column. Then status of the process, it is ongoing state or other limit. If it is not, if it is ongoing, then simply select ongoing and go ahead. Then if the process is state, then you have to fill in the relevant details why the process is state. Then section 1. Section 1 deals with the stay on CRP by any court, tribunal, or under the drop down you have to select yes or no. So this is the monthly progress report where you have to give the details like serial number, nature of stay, name of the court or tribunal who has granted the stay, which NCLT bench this matter belongs, date of order, copy of the order you have to attach. If there any remark, you can fill here. Category of applicant on which application stay is granted. Details of the appeal, if there is any appeal, then multiple row you may add depending on the requirements, depending on your requirements. So then part B is there. So under the part B, in case there was, in case stay was reported in last month. So then here you have to repeat the data. Then I'm not going into this. Then if ongoing. Now coming to the this section B, this is filled in every month. So status of ongoing process, drop down is there, going as per the model timeline or delayed. Here you have to select it. If it is going absolutely as per the timeline, then going as per timeline, then, and if it is delayed, then select the delayed. So if it is delayed, then the reason you have to put in the reason there. So what may be the reason? Admission order received late. This may be the reason of the delay, or stay by any authority. Then settlement between the parties, replacement of the RP, claim not received, COC not constituted, RP not able to take any custody of the assets from ex-management, non-cooperation from the ex-management, asset record detained by the government authorities or ED or whatever authority. So whatever reasons of delay you have to select here. Almost each and every possible reason is given in the under the drop down. So you have to select here. Then latest activity completed. So under the drop down, what the activities have been completed, like public announcement issued, COC certifying report has been filed, IM submitted, EOI issued, RFRP given, final list, plan received, so on. So there are certain each and every event which is given in the drop down menu, you have to select the particular activity. So what the last activity has been completed, latest activities have been completed, here you have to select all these activities. Whether the periodicity of the COC meeting as per regulation, yes or no, you have to answer it. So that IBBI can track whether you are holding the COC meeting as per timeline. Then number of the meeting and date of the meeting you have to give in here what you have conducted in the last month. Then whether the composition of the committee change, you have to specify here regarding the change in the committee of creditors. So under this tab, serial number, name of the creditor, voting percentage, amount of admitted claims, and category. So these are the certain columns which here you will specify what is the percentage of voting have changed or what is the amount have changed. So that the which is bearing on the change in the constitution of the committee, composition of the constitution of the committee. Then cost disclosure you have to file each and every month. So under the cost disclosure, cumulative figures to be updated by the IP every month. Here, so what are those figures? So there are basically B and C, two type of cost. One process related cost that is given under B number, then going concern related cost under C number. So you have to give the cumulative figures of the total cost, and after this cost, the total cost will be populated, and IBBI will be saying that how much cost you are incurring in this particular process. So, and then after this, you will file this form by giving the declaration and signing digitally or through e-sign. So this is all about the CRP forms from 1 to 5. Can we take break for some time so that we can start liquidation and other presentation?
Yes, sir.
Okay, sir. So after 15 minutes, we will again resume with the liquidation forms and liquidation compliance related presentation.
Okay.
Okay.
Okay,
Okay.
okay, sir. Thank
Thank
you.
you. Thank you. So welcome back. Now let us go to the Form H, that is the compliance certificate. After the resolution plan is approved by the committee of creditors, and this compliance certificate is required to be filed along with the application for approval of the resolution plan with the Honorable Educating Authority. So under this Form H, we will go the contents very quickly. I will not take much time because we have already covered this under the CP5 forms, CP forms. So here, 1A, the Form H prescribes the details of the CIRP. So name of the CD, date of initiation of the CIRP, date of appointment of the IRP, regarding the date of public announcement, date of constitution of the committee. So here we have to specify the dates, all the dates. Date of first meeting of the COC, date of appointment of the RP, date of appointment of the registered valuers, date of issue of the EOI. In case you have issued the EOI more than once, then you have to give the dates of all the EOIs when you have issued it. Then date of final list of the eligible PRAs, date of invitation of resolution plan, date of submission of the plan, which was the last date. Then date of submission of the plan to the RP by the RP. What was the last date submission of the plan and what was the date of submission of the plan to the RP? Both are basically the same dates. Then date of placing the plan before the committee of creditors for its consideration. Date of approval of the resolution plan by the COC when the COC approved the plan, and date of filing the resolution plan with the AA. So these 16 informations are required. Then there are other informations also. Date of expiry of the 180 days, that is the date up to which the CRP ought to concluded. Date of each order extending or excluding the period in the CRP. Date of expiry of extended period of the CRP. So this is the last date after considering the extension and exclusion. Then fair and liquidation value as well as the total number of meetings held when you are filing this Form H with the along with the application. So if the 180 days has passed, what are the reasons of delay? You have to specify. And as the RP, you have to certify. What you have to certify? That the said resolution plan complies with all the provisions of the IBC code, IBBI, IRCPC regulations, and does not contravene any of the provisions of the law for the time being in force. So this certificate specifically has to be given by the RP. Second point of the certificate, that the resolution applicant had submitted an affidavit pursuant to section so and so under section 29A of the code to submit the plan. The contents of the said affidavit are under. So then are as under. So the complete contents of the affidavit you have to specify here. Then under the certification, the third number of certificate you have to give that the plan has been approved by the COC in accordance with the provisions of the code and the regulations. The plan has been approved by how much percentage of voting you have to specify here after considering its feasibility and viability and other requirement specified by the CRP regulations. And finally, the voting was held in the meeting of the COC Here you have to specify the date of the meeting and where all the members of the COC present, or the voting of the COC members were sought by electronic means. So, and the requirement of opening of the voting lines was also to be certified by the RP. So this Form H certification is very relevant. Here the RP is certifying that all the requirements in respect of the particular plan has been complied with, and it is complying all the regulations, what percentage of voting is held in, and what is the date of voting, when the voting is. So everything is here in the Form H. And Form H is required to be submitted with the applications in case the plan is approved. And there are other details which is also required here. That is the details in respect of successful resolution applicants. Here you have to mention the name, its nature of business, relationship with the CD, and the was eligible to submit the plan, whether the CD was MSME or not, and the due diligence conducted by the RP. So everything in respect of the SRA has to be specified in the Form H. Then each and every clause which is specified here in Form H is given in brief under this Form H. So here you have to first write whether the CD is MSME or not, what is the business of the CD, total amount of the claims, including what is the principal, what is the interest and penalty from each of the creditors. If there is any claims in respect of the corporate guarantee, you have to specify. Then what is the resolution plan value under the plan? You have to specify here the resolution plan value, and this resolution plan value will include the fund infused, proposed to be infused by the SRA, the insolvency process cost and all, and the percentage of voting in favor of the plan. This you also have to give in. Then the details of the implementation of the resolution plan is to be given in the Form H. So here in brief, the amount of the performance guarantee, source of fund, capital, restructuring, terms of the implementation of the plan, monitoring committee, and effective date of the plan. So this all the details from the plan to be extracted and to be specified here in Form H. Then list of the financial creditors. Here you have to specify what are the creditors, financial creditors, what is the percentage of voting they assume, and whether they have assented, dissented, or absent from the voting on the resolution plan. Then what is the realizable value each and every creditor they are getting. In case of real estate, CDs, provide the monetary value of the flats, etc., given to the allotee. So if the plan is like that, the certain creditors will get the flat, then you have to monitor, you have to derive the value of it. Fair liquidation value, percentage of realizable fair value, and every thing in respect to realization to the creditors is happening. Then you have to specify in terms of quantum of the amount. Then details of the realizable amount, category wise. Secured financial creditors, how much they will be getting. You must be saying in the CP form when I was discussing. So secured financial creditor under the class, secured financial creditor, dissenting or assenting unsecured financial creditors, and the operational creditors, uh, whether they are government, workmen, PF, employee due, and that. So every category of stakeholders, what are the amount they have claimed, their amount, admitted amount, what amount they are realizing, and what is the percentage of the total claim. So this all has to be given in the Form H. Then at the point number 8 in the Form H, you have to give the time frame proposed for obtaining the approval. So here under the resolution plan, SRA gives the timeline. Then after the approval of the plan is so and so time, they will seek the approval. Here you have to mention under the proposed framework for approval of from the relevant authorities. Then step to be taken by the concerned parties post approval of the plan. So in the timeline, there are certain steps which is specified in the plan itself. So here you have to specify in Form H. And regarding the avoidance transactions under each of the sections of the transaction, whether it's preferential, undervalued, extortionate, or fraudulent, you have to mention the amount, who are the beneficiary, how this will be dealt, and the date of filing of the application. So everything you have to specify here. So I'm going quickly here. And what are the pending IAs? You have to specify this fact also in your Form H, that these are the IAs which are pending before the bench, and the nature of the IAs and the applicant's name, everything you have to mention here. And other compliances regarding estimated liquidation cost, estimated uh, liquid asset, contribution required, and pensicator. So this is all as per regulation 39. So where while approving the resolution plan, the COC has to give the pass the resolution and inspect of various section under regulation 39B. So you have to specify here the requirements of 39B. Then committee recommended for said going concern. This is I'm leaving this. Then declaration. So this is what Form H specify, and under the annexures, if you can see that declaration with respect to compliances of the provisions. So each and every clause of the resolution of the section or code under the resolution plan has to be complied with, and this every clause you have to, as a RP, you have to see and you have to verify whether these are complied or not. So if these are not compliant, that the resolution is not going to pass by the adjudicating authority. Then like section 25 2H 29A 30. So I'm not going in detail. So since these are the compliance part, so that is why I'm covering this. Section 30, subsection 4, the resolution plan is feasible and viable according to the COC. This has to demonstrate before this bench, before the authority, that yes, this is discussed by the COC. Then resolution plan has provisions for its effective implementation, that is also there. So you can see each section, each regulations is specified here while you are going to file this Form H, and this form is filed by the RP. So this was all about the CIRP timeline, CIRP form filing, Form H. Now moving forward, let us discuss the liquidation form. So under the liquidation, let us first discuss the timeline. Just a second. Just a moment, I am sharing the timeline. Then we will go to the forms. So, before we start with the lake form, let us first go through the timelines which are prescribed under IBBI liquidation process guidelines, process regulations. I'm sorry. So, section 33 and section 34, two sections are relevant where commencement of the liquidation and appointment of the liquidator is specified. So, let us take the liquidation commencement date LCD as T. Then the first requirement is T plus 5. Within 5 days of appointment of the liquidator has to give a public announcement in Form B. After this, within 7 days of the liquidation commencement date, the second activity is appointment of the registered valuers under each class. Then Regulation 31A 6, which specifies that first meeting of the SCC. So within 7 days of the liquidation commencement date, first meeting of the SCC is required to be held. Then section 38(1) with regulation 17, 18, 19, 20 and 21, which says that the timeline of T plus 30. What is this? This is submission of the claims by the creditors, intimation of decision on relinquishment of the security interest. So, the secured financial creditors or the secured creditors who are having these rights over the who are having the security interest over the assets, they mandatorily has to decide whether they want to relinquish their security interest into the liquidation state or not. So this is the timeline within 30 days. Then T plus 44 days, which is withdrawal or modification of the claim. This is within 14 days of the submission of the claim. Then verification of the claim within 30 days from the last date of the receipt of the claim, that is T plus 60 days. It is within 2 months from the LCD. The liquidator has to verify the claims and constitute the committee of creditors within this 60 days of the LCD. Then initiation about this intimation about the decision of acceptance or rejection of the claim just after 7 days of the verification of the claim, that is T plus 67. Then T plus 75 means filing of the list of creditors, that is 45 days within the last date of the receipt of the claim. You have to intimate to the you have to file the list of creditors, list of stakeholders basically, not a list of creditors, although all the stakeholders may or may not be the creditors. The appeal by the creditors against the decision of the liquidator within 14 days of the receipt of such decision. And T plus 81, then preliminary report to be filed within T plus 75 days with the AA. So this report is first report. It is very crucial report. It contains each and every aspect of the asset of the CD, and along with this, the asset memorandum is required to be filed within 75 days of the LCD. Then coming to the progress report. So the progress report of each quarter required to be filed before 15th of every succeeding month of the end of the quarter. So there are 4 quarters in a year, which ends on March, September, December, and June. So after this, within 15 days of the end of the quarter, you have to file this progress report, and this progress report filing with the adjudicating authority. And along with this, asset sale report is also to be included wherever it is required or where the sale is actually happened. Then regulation 37(2), information to secured creditors. This is within 20 days of the receipt of the intimation from secured creditors. So within 21 days, date of intimation plus 21. So within 21 days, you have to intimate these secured creditors, whatever information is required. Then distribution of the proceed within 90 days of the realization. And the last regulation 10(1) application to A for disclaimer on onerous property. So this is T plus 6 months. So this is the timeline. Now I am going to the lake form. So this lake form, earlier there was no such requirement of filing of the liquidation form as was there in case of CIRP forms. So CIRP forms were prescribed, then it was revised with the CP forms. Now the IBBI recently by circular number 91/2026 had launched the new revised form version which are required to be filed by the liquidator under the liquidation process. So in the same line, why the need of launching this revised form under liquidation was arise. This is same as in the CRP forms. Accordingly, the CRP form as well as the liquidation form which were designed to ensure a reduced compliance burden on the IPs. This is to eliminate duplications. This is to rationalize the various data. And initially, these forms, when launched, there were certain technical difficulty also. So the IBBI also relaxed to to some extent that the IP are not subject to any penalty during certain period. So let us go to the revised framework. So the first form which the liquidator is required to file, that is LIC 1, LIQ LIC 1. So why this LIC 1 and when it is to be filed? So the date, that is 10th of the subsequent month. The date of the public announcement when it is made in a particular month. So this in the subsequent month, this LIC 1 form is required to be filed. So if you see the heading of the LIC 1 form, it specifies that from commencement of the liquidation till public announcement. It means when you made the public announcement, it means public announcement is made in a particular month. So in the next month, before 10th of the date of that month, you have to file LIC 1 form with certain specified details. So after this, the second form has been prescribed, that is LIC 2. So this LIC 2 form is progress report on the liquidation process during the quarter. So after each quarter, this LIC 2 form is required to be filed, and this form will include status of process, details of valuation, realization, PUFE transactions, stakeholder committee meetings, what are the receipts and payments by the liquidators. So all these informations in the LIC 2 form, that is the progress report you have to file as a liquidator, and the filing date is 10th of the subsequent month after the progress report you have filed with the AA. So here, suppose the quarter of the March ends in the month of March, and you have to file the form. You have to file the progress report with the AA, that is within 15 days of the next month, that is 15th April. Then you have to file this lake form on the 10th of May. It means from the month in which progress report is filed with the AA, then in the subsequent month, that is month of May, and the due date is 10th of the subsequent month. So Liq 2 form is required to be filed. So first form is liquidation 1 form, which arise when you publish the public announcement, when you give the public announcement. Then when you file the progress report, then this Liq 2 arise, requirement of filing the Liq 2 arise. Then the next form is LIQ 3, Liq 3. Liq 3 will be filed after submission of the dissolution or closure application to the AA. When you file the dissolution application or closure application with the adjudicating authority in any month, so in the next month of the filing of the application, within 10th of the month, you have to file the Liq 3 form. So Liq 3 form will contain the details of the application, unclaimed process, realization, distribution, receipt payments, and everything which is there in the application. So if you see the heading part of this Liq 3, from last progress report to the application for dissolution or closure of the process. So here you have to file the details of the application. And the last form is the Liq 4 form. Liq 4 form will be filed on getting the order or disposal of the applications. You can say when you file the dissolution application, it is adjudicated and passed or order is given on this application. Then within 7 days of the order, you have to file this Liq 4 form. And if you see the heading of the Liq 4 form, it is from application of dissolution closure to order for the dissolution closure of the process. So the details will be from the application till the order. And what will this include? This will include the details of the distribution of the proceed, receipt and payments, details required in case of forms as carry forward, and so on. Now coming to the other clauses of the circular for the better understanding. So in this form, in this circular, indicative templates of each form is given as per annexure. When this form was notified, so here the IBBI has given relaxation that no penalty will be levied on delayed filing of the forms, if any, during the initial quarter, that is January to March 2026. So this is over now. So March quarter is over. So if there was anything, the IBBI proposed that there will not be any penalty. All subsequent filing shall be made through the revised forms. So earlier there was forms prescribed. So all the forms relating to the Liq will be filed through this uh, e-platform. So I will show you the platform also. If you see the point number 10 of this circular, the IBBI says that it is urged that several IPs have requested permission to amend already filed forms to correct any error or omissions. So there were cases when the liquidation form were filed earlier and there were certain errors or the omissions was there. So IBBI allowed modification of these forms and without any charging any fees and all. So this was allowed by the IBBI for the previously filed forms. So if you see this, who will file the form? As on the IP shall submit the form before the due date and subsequent subsequently modifies the same before the due date, no fees will be filed. So if you are, as long as you are filing this form within due date, and you are modifying this form within due days, you will not be subject to any penalty or any fees, whatever it is. And it is further clarified by the IBBI that IP who does not comply with the applicable provisions of the code and the regulation, he shall be liable for failure to file this form and inaccurate and incomplete information. So warning is also there. You have to comply with the filing part. Now let us go to the content of the Lake 1 form. So this Lake 1 form is required to be filed when I am highlighting on or before 10th day of the subsequent month after public announcement has been made. So here again different sections are there, like A, the details of the CD. Here the name, SIN number, industry, process email ID, whether CD having any active business or not, details of the public announcement. In case of no or delayed public announcement, you have to give the reason also. So this liquid form is very precise form. You have to file this. Then form number Lick 2. Lick 2 is here. This is the progress report filing form basically. So here you have to file this form citing what is the progress report, what is the timeline, you know? And if you see the columns, different columns of this process, whether the process is ongoing state. So here you have to give the nature of a state. It is a state, then name of the court or tribunal who has stayed this process. Then valuation regarding details you have to give, and you have to attach the progress report as well as, and date of the order during the quarter, and under the valuation, average value, fair value, all you have to give here under the progress report. Then item number D in this lake form, details of the asset realized till first quarter, during the current quarter, and cumulative. So this is the quantitative details you have to give in this form. Then details of the assets which are not being put up for sales, you have to specify here what are the assets remaining for sale. So here you have to give the class of assets, whether they are land, building, plant machinery, or SFA. Under the drop down menu, you have to select then estimated realizable value and realization not getting. Then you have to attach the specific required details also. Then PUFE applications details you have to give here. So this is almost in the same line when we are giving these details under the CRP forms. So I'm not going in detail to this. So here the amount, nature, and filed by the RPO liquidator, whosoever filed, amount ordered to be brought back. So status of the application, this all you have to give in this form. Then regarding the stakeholder consultation committee, this is important. So here you have to give the details of the stakeholder consultation committee meeting, date of the meeting. In case of gaps of the two consecutive meeting more than 30 days, state the reason why it is so. Receipt of the payment, receipt and payments details you have to give. What are the receipts made during the quarter, and what are the cash balances, bank balances, contribution to liquidation cost. So every details and realization, receipt and payment, and regarding the auctions, you have to fill in here. So unpaid CRP cost, liquidation cost, cost incurred in running the business. So these all details required to be filled in. Then status of the liquidation process. Here under the drop down, you have to select what is the status of the liquidation process, and the reason of liquidation process not is completed in the stipulated timeline. Then you have to give the reason and remark also. Then this form will be filed. Then Liq 3 form is there. Liq 3 form will be required to be filed when? On filing of the application for dissolution. So once you file the application up for dissolution or closure, you have to fill this form. So details of the application, case type, case number, case year, filing number, every precise details so that the data may be fetched from the NCLT. A copy of the application you have to attach, and if there is any unclaimed process, you have to give also the details of the unclaimed process. Then details of the asset realized during the last quarter. So from the last quarter, the balance will be automatically populated, and for this quarter, you will fill in the data and the total will be there. So after this, the details of the assets remain unrealized or unassigned. It is to be filled. Precise detail is there, and the reason of such unrealization, amount realized during the quarter. Then the data of distribution under section 53. So if you remember section 53, here you have to give all the details which are required to be distributed under section 53. So insolvency cost on the first priority. This you have to give a number of the claimants, amount of claim, total amount admitted, amount distributed, and remark. So insolvency process cost, liquidation cost, including liquidator fees, the liquidator fees, secured creditors, what amount they are getting, workmen for 24 months, and employees for 12 months from the liquidation commencement date. Then unsecured financial creditors, statutory dues, secured creditors who had enforced security interest, operational creditors. So the waterfall mechanism has been prescribed, and under that hierarchy, all the heads are given. So you have to fill in how much amount you have distributed, what are the claim and all. Last is the equity shareholder. So they will get if anything is remained. Then details of the security interest you have to give in, which is not relinquished by the secured financial creditors under section 52. Here you have to give in. Then receipt and payment of the entire liquidation period, cash, bank balances, FDR, insurance, mutual fund, etc. Then contribution to the liquidation cost from the financial institutions or banks, realization from the assets. So every receipt and payments headwise it is given. Then what are the refunds from the statutory authorities you have received? So everything unpaid CRP cost, RP fees, where you have paid the interim finance, RP fees, professional fees, cost of operating the business, statutory dues, and other whatever remaining balance is there. Then the liquidation process cost, you have to specify each and every heads of expenses like liquidator fees, support service fees, marketing expense, litigation expense, cost incurred for protecting the assets, fees paid to the other professionals who are engaged in this process, or any other cost. Then going cost paid, contribution repayment to the COC members, and finally the attachment with this form, the copy of the final report, copy of the application for dissolution, and compliance certificate form H. So form H in the same manner when it was as it was given in the CRP process after approval of the plan. So this form H is also required to be given under the liquidation. Then after this, the last form prescribed, it is Liq 4. So Liq 4 form basically after the getting of the order, and this form is required to be filed within 14 days of the passing of the order. So in this form, you have to fill the details of the order, like date of the order, liquidation process was closed by, here you have to choose the date, then approval or compromise if it is there, then sale of corporate as a going concern, dissolution of the corporate debtor. So whatever relevant points are there, you have to check in and fill in. Under the point number B, whether any change in distribution as provided in table G in Lick 3. Since you have already filled in all the details in Lick 3 form at the time when you are filing this dissolution applications, if there is any change, then you have to specify what are the changes and you have to fill in. So all the amount will be auto-populated here, which you have already filed. Only change you have to mention here and it can be edited. So this all we have already discussed in Lick 3. So this is for the final order. So order you have to attach here and this Lick 4 form is filed. If you see the form H, compliance certificate, this you have to file with the dissolution applications as a liquidator. So under the let us go through the contents of this form H. That is name of the CD, case number and bench, date of initiation of the liquidation, date of appointment of the liquidator, date of commencement of the CIRP, date of RP during CIRP, and his registration number, name of the RP, name of the liquidator, date of publication of the public announcement in Form B, date of intimation to the registry and IUs, if any, about the commencement of the liquidation, date of handover of charge by the RP, date of submission of compliance as directed by the AA, if there is so, date of appointment of the registered valuers, date of notice for uncalled capital, date of realization of uncalled capital. So all the details of the liquidation process, what is the date of the opening of the liquidation bank account, the date of constitution of the stakeholder consultation committee, number of meetings held uh, by the liquidator in this process with the stakeholder consultation committee, date of submission of the list of stakeholders to the adjudicating authority, filing of the progress report, the number of progress report filed, all has to be given here, as well as the fair and liquidation value and date of public notice for auctions. These details to be given in the form H. Date of order of the AA to dispense with the public notice for auction. If this order is achieved by the liquidator, then this details also to be disclosed in the form H. Then date of permission for A for physical auction, private sale, or distribution of unsold asset to the stakeholders, and date of permission of the liquidator to realize the unrelinquished security interest by the secured creditors, and modified list of stakeholder and date of submission to A. So all the dates you have to specify in form as date of first realization, then date of second realization, first distribution, second distribution, submission of the progress report, date of submission of the asset sale report, date of submission of the quarterly reports, 1, 2, 3, 4, whatever quarter report you have submitted. So you have to give the date of submission and with the audit report also, because in each of the quarter, which is ending on March, audit report is also required to be given. So these reports are to be submitted, and the date of reports and submission to be given here, and date of intimation sent to the various authorities uh, like PA, PSI, Income Tax Department, GST Department, Inspector of Factory. So all the intimations date has to be specified here. date of deposit or unclaimed dividend or undistributed proceeds, if it is there, then this also has to be specified, and amount deposited into the corporate liquidation account, date of submission of to the board and the authority under Regulation 5 of Regulation 46, and date of final report prior to resolution. So all these dates and amounts has to be specified in Form H. Asset memorandum details in column number 3, you have to give in. What is that? That is asset, mode of sale, estimated liquidation value, realization amount, date of transfer of the to the liquidation amount. So all these amount has to be given. Then regarding the stakeholders distribution, CRP cost, liquidation cost, and what amount have been distributed to the stakeholders. This you have to give in details, citing also the amount claimed and admitted and the percentage of the amount distributed of the amount of the claim. So this is given. Then liquidation process has been conducted in a timeline. So whatever the timeline is given, you have to specify. If there is any delay or deviations, you have to give the reasons also under 6 number clause. Then under 7, the resolution application has been filed before the expiry of the period of 1 year or whatever it is. So you have to give the reason if it is filed late or delayed. The details of the applications filed or pending at the time of filing of this resolution applications, like preferential transactions or whatever applications are there, you have to give the reason. You give the details of the application, and here the certificate also that all the information given is correct. So this is the Form H which liquidator has to file, has to submit with the report. Now let us come to the so this is lick 1, lick 2, lick 3, lick 4, right? So now we will move forward to the PIRP forms. I am saying, just hold down. Now, in the remaining time, let us go through this PIRP form. After this, we will take the question answers also, and we will show the login portal also for this quickly for the sake of understanding. And now, first circular number 92 of 2026. Which was issued on 6 March 2026. So earlier, before this circular, there was no modalities of reporting of the assignments related information in respect of personal insolvency of the corporate guarantors. So as you can see the heading, filing of forms to monitor insolvency resolution process of personal guarantors to the corporate debtors under the IBC and its regulations. So regulation 23 is relevant here. before this, before notifying this form, all the information in respect of PIRP related process was sent to the board through emails, which was time consuming and inefficient. There was no streamlined of information for the board or for the RP also in other sense. So Regulation 23 of the insolvency process for corporate for personal guarantors to the city specifies or provides that the RP shall file the forms along with the enclosures as notified by the board through circular. So by this Regulation 23, this circular is issued and the forms are notified. So under this, what is the purpose of this form? The purpose of notifying this circular is to ease of compliance burden on the IPs. So to ease the compliance burden, a set of electronic forms have been prescribed and notified. These forms are very crucial to monitor the insolvency process of personal guarantors to the corporate debtors. This is what are the key benefits of these forms? So the key benefits are same as the improving the efficiency, minimizing the likelihood of the errors, omissions, and have the uh, rationalized flow of the work, the flow of the informations also. So there are certain PIRP form which have been prescribed. So let us go one by one. So there are basically total 6 number of PIRP forms. 1, 2, 3, 4, 5, 6. I am going one by one. One is PGIRP1. So this PGIRP1 is required to be filed 10th of the subsequent month after the submission of report by RP to the AA under section 99. As you know that once the application under section is filed, under section filed and the report under section 99 is filed for admission of the process, this PGIRP1 form is required to be filed. What this form will include? This includes the amount of debt and the details of the guarantee and all. So you will find everything in the application itself or on the basis of application which is filed under section 94-95, admission order is given. This 99 report is filed. Then next form is PGIRP 2A. So this PGIRP 2A is filed subsequent month on or before 10th, and that is after order of rejection of application under section 100. So once the report of the RP is filed to the AA, after filing of the report, either this PGIRP is basically admitted or rejected. So once it is rejected, then this PGIRP 2A is filed, and if it is approved under section 100, then PGIRP 2B is filed, and this form is to be filed within 10 days of the subsequent month after a public notice is issued under section 102. So under section 102, in the same pattern, when we publish the public announcement for inviting the claims, the public notice is issued by the RP.
Sir, have you done any practically? Anybody has already filed?
Yes, sir.
Sir, no, sir, whatever the forms you are discussing here,
Yes, please.
forms are not properly implemented. The dates are not picking up properly. We tried to do this, sir.
When you tried, sir?
No, if you see PGIRP 1 form, that has to be filed after filing the 99 report. And once the public.
Sir, I got your point. Let us finish this, then I will go through the portal, right? We will show you how this form is filed. No issue.
Okay, sir.
I personally filed, so there is no question of whether I have done practically or not. I will show you, right, sir? No issue.
Okay, sir.
Then PGIRP 3 form that is filed before 10th of the subsequent month after the submission of the report by the RP. So this form PGRP 3, then PGRP 4. PGRP 4 timeline starts when after the order of the AA on repayment plan is received. Then PGRP 5, that is after the passing of the order under section 118(3) and or 119. Then finally PGRP 6 form is there. That is after the end of the each quarter. This is the quarterly form. Basically, this RP has to file. Now let us move to the first. इसी को दिखा देते हैं पहले. PGRP 1. Just hold on, sir. No, I'm stopping this. I'm sharing my login. Just hold on, please. शेयर कर सकते हैं हाँ. So is it visible, sir? I am getting it shared.
Yeah, this is visible.
Okay. Come to the PGRP form. हाँ ठीक है. अति तुम बता सकते हो, मैं अपना म्यूट कर लेता हूँ. So these are the PGRP 1 form which I have filed for 3 personal guarantors. What was the issue, sir? Can we discuss here? What was the specific issue? If we can discuss here, sir.
Sir, I'll just a minute, sir.
Yes, please. Or whatever tab you want to like me to open, I will open it and will show you.
So 1 minute, sir. Actually, I am preparing myself where I have faced the problem. Just a minute.
Please tell me so that the doubts may be cleared. You can see this. We have submitted all these forms on 13th April 2026. Right?
Sir, no, all forms are operational, sir.
Sorry, sir?
No, all the forms are operational now. All the forms.
Sir, whatever, see, PGRP 1 form I have filed.
No, what I'm asking, 1, 2A, 2B, 3, 4, 5, 6, all are operational now.
Sir, what I'm telling, I suppose all the forms are operational. What I have done so far, 1 is filed, 2 is filed, right? And
Uh,
3, I have not yet filed personally, but I'm not getting any error from anybody else. Anybody else. So if you can share me, then we can discuss here.
sir, have you filed 6, sir? 6.
No, sir. 6 has not yet been filed.
But 6 also
There is some issue in 6.
So what IBBI is doing is, if anybody is making a note, then they are rectifying the defect, because these forms has to be tested properly before making it public.
No, sir. That is why they have given the relaxation, na. They have said that till 30 June you can file it without any problem. If there is any issue, then you can mail it. The issue will be rectified, and it happens that now every time it happens when the new form is certified, uploaded or revised. So whatever problem is there, you can very well mail it to the IBBI at support, what mail ID is given in the circular. And up to 30 June, it is there will not be any delayed penalty or whatever it is. So up to 30 June, there is relaxation by the IBBI. So this is
So relax.
testing phase. You can say this is in the testing phase.
No, sir. IPs are already loaded with so much of work. Then again, if they test on us, we lose patience,
So
because they cannot test on us. We keep no. My intention of telling this one is, no, before making it online, before making it live, they should have run multiple simulations. They should have run.
I'm not opposing you. I'm not against you. Whatever you are saying, it is correct. So,
I'll tell you a simple problem. I'll tell you a simple problem. The admission of the application will happen only after the Section 99 report is filed. When we are filing, because today we are filing that the cases which have been dead 2 years back or 1 year back, we are dealing. Now, if we are going to file Section 99 report of a case which is already done previously, that is not accepting beyond, because 99 report is filed maybe 3-4 months back before the admission is done. But the date what it is showing is the admission date it is showing there. But anyway, I think that problem has been rectified now.
yes. There was some issue, and the issues still persist in some of the forms. Then we all have to inform to the IBBI that please rectify this. So there is no issue. So
No, when they have problems with the form, they should not have gone live. They should have taken some more time to do all this, because now the PGRP was live since 2019 itself. It
you
was
are right.
notified.
I think our IPA is here, and we all would request the IPA to communicate to the IBBI for the problems being faced by the IP
No, sir.
of these forms, right?
Sir, my simple question is, when they have taken 5 years to launch these farms, they should have taken another
Sir,
3-4
I am
months. before
like
life.
kindly appreciate. I am not the representative of the IBBI. I am like you, sir. I'm
Uh,
the IP like you. Whatever problem you are facing, I also faced, and I have intimated. I have written the mail.
my intention was the IPA should take it up with IBBA
Yes,
with
yes.
all.
IPA should take it up, and I think IPA will take it up. है ना? I will inform also, and you please inform
Yes,
to the
yes.
IPA. Yes. Thank you, sir. So
Thank you for your clarification, sir.
yes. ऊपर आओ. तो मेन डैशबोर्ड पे एक बार आ जाओ. Yes, main dashboard. Yes. Okay. So if you can see, the all the forms are there: liquidation form, PGRP form, modification, PGRP form, liquidation form. So there are so many forms. So under these steps, we used to file these forms. And apart from this, there are yearly and half yearly compliances also, which we have to take. So इसको हटा देते हैं, हटा दो इसको. बस फी पार्ट. हाँ, फी पार्ट पे चले जाओ. हाँ, yearly compliances na. Under the yearly compliances, we have to file this form E and form EA. Two forms we have to file. Form EA we have to file on quarterly basis on payment of the fee to the professionals, and form E we have to file by paying 1% fee of our earnings as IP from whatever sources as working as IP, whether it may be RP, IRP, liquidator, AR, whatever it is, we have to uh, pay 1% fee. And apart from this, half yearly return has to be filed with our IPA also. So this is the yearly compliance and half yearly compliance we have to ensure. Apart from this, some requirement of getting the CPRs, for which we are attending the programs and seminars also. So for the CPRs, इसको stop कर दो, मैं share कर देता हूँ. CPRs provisions एक बार मैं share कर देता हूँ. हाँ. So for the CPRs, we have certain provisions. As an IP, after the recent amendment, which was there on 13th August 2025, every IP, this is the relevant part. Every IP has to get at least 30 CP hours in a year. 30 credit hours of CPE in each calendar year. And this CPR is required to be completed in person also, in terms of certain percentage. If you see this, minimum percentage of total CPE credits to be obtained through in-person program in the year 2026, in the current year, calendar year, 40% minimum CPE hours would be required out of 30. 40% would be 12. So in percent, 12 CPRs will be required. Then in 27, 50%, and in 28 and onwards, 60% of the CP hours in person to be obtained. So these are the requirements of the CP hours and this CP hours is required to be complete at the time when we file our AFA every year. So this we also has to ensure as AIP. And how we can get the CP hours? CP hours from the workshop, conference, seminars, we can get. This is the indicative credit hours as per table. Probably 2 credit hours are there. Then acting as a facility equivalent to the duration of the activity. Publication of the article, you will get the 4 hours. Publication of articles in a journal of the board, IPA, 8 hours are there. Publication of a book, 30 hours will be granted. Completing a 2-year post-graduation course, 20 hours. Completing PhD, 40 hours. Pass in limited insolvency exam, 40 hours. Pass in valuation exam, 20 hours. And acting as a NCLT or NCLT members, you would be assumed that you are getting the complete CP hours. So these are the requirements in short about the CP hours. So every IP should get. Now we will take the question answer. Yes, sir. Anything, because since my time is getting over in few minutes, let us have some discussions. If any questions are there, we have got certain queries regarding lunch break. This IP will stakeholder includes whom all. So regarding stakeholders, under the liquidations, even equity shareholder is also the stakeholder.
Sir, my name is AKG Shekhar.
Yes, sir.
When you discussed the timeline of liquidation,
Ji.
the first SEC meeting you mentioned 7 days.
Within 7 days, yes, sir.
But the SEC is formed only after 60 days.
Yes, sir. That is correct. So there is provision in the liquidation regulation itself. Whatever the COC is there, that will be deemed as the SCC for the purpose of this first meeting. So,
okay, thank you.
Yes, sir. Any other questions, sir? I'm going to the chat box. If any.
One more thing.
Yes.
This IPA forms and IBBI forms, if it can be made common, it will reduce the burden of the IPC.
This is very good suggestion, sir. So I think it will be, I will write to the IPA in this regard. This is good suggestion because it is burdensome to all of us. Yes, sir.
It will be, if it's a common one, it will be easy so that
Yes,
it
yes,
can be
yes.
shared to both.
Yes, sir. There is no point in filling the form duplicate, one in IPA, another in IBBI. Yes, completely agree, sir. Yes.
Thank you very much, sir. Thank you.
Any other query? So, Anjali ji, can we conclude this session? Anyone from IPA?
Sure, sir, we can
Yes.
conclude.
Yes, sir.
Thank you very much, sir, for such a knowledgeable and wonderful session. Sir, please share the presentation also
Yes, yes.
because
Although,
you highlighted now.
yes, yes. I will share it, although I have not given my presentation based on that, but I will
Yes,
surely
yes,
share.
but you have highlighted the
Yes, yes.
portions that
Yes, yes.
high.
I will share each and every circular and all. Thank you, Anjali.
Okay.
Thank you.
Thank
Thank you,
you.
participants, for bearing me. Thank you so much. Thank you.
Thank you, sir.
Okay, now there is lunch break. We will reassemble at 3:30 p.m. for the next session.
श्री लक्ष्मी जी, आपका कैमरा ऑन है।
Good afternoon, everyone. Can we start now? Participants, are you here?
Yes, yes.
madam. Yes.
Good afternoon, everyone. Welcome back after the lunch break. Now the session will be taken by Sandeep Bhatt sir on the topic IBC amendments and its impact on resolutions. Let me briefly introduce Sandeep Bhatt sir. Sir is cost accountant, IP and lawyer. He is promoted director of Share Insolvency Professionals Private Limited. He is also running partnership firm in name of SK Bhatt and Associates Cost Accountants. He has experience of 28 years. He has resolved over 40 IBC cases. Now I request sir to kindly start the session, please.
So, friends,
Sir, you can start now.
very good afternoon to all of you. I welcome you all over here in this wonderful gathering. The renowned IPs are present over here, and it's like a very fun-taking session wherein we have been experiencing so many things in our professional journey, particularly in the IBC. And we have countered several difficulties, issues, and we have also tried to resolve all those things. And whenever I visited the Honorable IBBI, then they told that in Parliament, so many MPs were targeting the RPs. Then I told that every MP is having business directly or indirectly. So the IPs are soft target. So no issues. But we are very much thankful to the IBBI and other stakeholders who have come up with certain amendments in the Act as well as in the regulations. And we all shall be meeting most probably on 28th in the IBBI 10 years celebration. So we will be interacting there also. So before we proceed, I think that we all are having a very good exposure related to whatsoever has been told by our FM in the parliament. So, several aspects had been briefed by her in the parliament. I am not going into detail into it. But the last date of submission of our comments was originally 28th April, and then on our request it was increased to 5th May. I have already circulated the gist of all the suggestions which were still posing a problem. And in the previous sessions also, with the ICSI, we are very much thankful that they are holding regular programs on different topics. So, in those sessions also, we had deliberated in detail related to several factors which are still posing issues even after amendment in the IB code and the regulations. So, we will cover up it later on, but to brief the relevance of all these amendments in the resolution process and the liquidation process, let us have a quick look on the aspects which have been dealt by the regulator in amending the several provisions of the IB code And regulation I am not touching today because previously I think that on 24th and 25th of last month, a regular 3 hours session was there on the different regulations. Today we shall be covering only the IB Amendment Act 26. We all are aware that the presidential assent has been received on 6th April 26. And now different provisions have to be implemented. And its implementation will be notified, and we are sure, as per buzz, as per discussions, that several provisions may be implemented with effect from 28th of this month, wherein the IBBI is celebrating its 10th year of formation. So likewise, the different provisions of the regulations will also be implemented from the date of their notification. Okay. So screen is visible to all of you, my dear friends. We will be discussing in between us also after completing this, because your insight and your practical exposure, because we all are having different sets of practical exposure in our IBC process. So your experience, your suggestion, your guidance will also benefit our friends who are present over here. And we are very fortunate that such an experienced and knowledgeable fraternity is with us today. So now we are starting a brief presentation over the Act, Amendment Act 2026. So overall, we may see that there has been 72 amendments in the sections. The 72 sections have been amended. And now one new chapter, 4A, has been added. And border insolvency has been prescribed. And we have prepared approximately 28-29 slides for your overview. And after this, we shall also be covering the issues which could not be resolved even after this amendment. So that we have already suggested to the regulator to look into that, and we are quite hopeful that as per our suggestions and suggestions given by the ICSI, we have forwarded our suggestions to the institute also. So they have also forwarded it to the IBBI. We have also shared all those suggestions to our insolvency professionals by mail. We have created a group, so in that we sent everything. So now you see that in the table of contents, we have covered all these aspects which have been planned or amended by the regulator. So in slide 1, we are giving you the background and objective, definitions and clarifications. So section 3 and 5 has been amended at several places. Financial creditor application. So if the application is being filed by the FC, so there has been amendment in section 7. Likewise, OCs and voluntary CIRP. Then there has been a procedure changes in withdrawal of admitted application under section 12A. Moratorium and COC oversight, section 14 and 21 has been clarified. Resolution plan enhancement, it has also been clarified. Likewise, liquidation avoidance and section omitted. There has been certain sections which have been omitted. Okay, so now you see that new chapter 4A, creditor initiated process, which they call CIIRP process. has been added. Group insolvency, Chapter 6A has been added. Voluntary liquidation, cross-border and e-portal concept has been put into the system. Personal insolvency and bankruptcy reforms are there. IBBI and regulatory reforms are there. And whenever we shall be discussing, we shall also be covering up the issues associated with that. Impact assessment, omitted sections summary we have given, which sections have been omitted, and key takeaways. What are the gains after all these exercise of amendment? And then the conclusion part is there. Kindly hold for a while. Yes. Background and key objective. The IBC Amendment Act 2026 received presidential assent on 6th April 26. It is a landmark reform of the Insolvency and Bankruptcy Code aimed at providing resolution timelines, expanding creditor initiation rights, and strengthening the insolvency ecosystem. So these were the basic objects, and now as per our analysis, certain issues have been addressed very well, but certain important issues could not be addressed even after these amendments. Hopefully they will do it after our suggestions. At first, speed is there, strict timelines for adjudicating authorities with mandatory reasons for the delays. Now they have provided that learned A has to give the decision within 14 days, within 30 days. And if it is not decided, within that period, the regions have to be recorded in writing. How already there is provision in the IB code related to the mandatory timeline, but that timeline is applicable only to the insolvency professionals or IPAs or IU. It is not applicable on the court, but the Honorable Finance Minister, while speaking in the Parliament on the IB code, specifically stated that we don't wish to bind our courts within the defined timeline, but to ensure the process properly and timely, we are proposing 14 days and 30 days timelines depending upon the nature of application for the regulator, for the adjudicating authority also. Now we will see subsequently how it will be completed without strengthening the NCLT benches. We are having 3-4 dissolution applications which are pending for more than 4 years. Okay. New processes introduced creditor linked insolvency resolution process. The chapter 4A has been added. Cross border has been addressed. Section 240C has been added. Group insolvency, new chapter 5A has been added. Transparency, strengthen evidence transaction regime and fraudulent trading rules. The problems which we were facing previously, that our fraudulent and evidence application is also pending, and our resolution plan or dissolution application is also pending. So till these pending applications are decided, neither the resolution plan can be approved nor the dissolution can follow. So to address this difficulty, there has been a very good amendment. Clarity, it provides clarity, resolve ambiguities on security interest, CIRP withdrawal and resolution plans. Now the moratorium is applicable. Now and the banks are willing to invoke the security interest. So the guarantors and everywhere, guarantors and everyone, they were arguing before the benches that moratorium is applicable, how they have invoked our personal guarantee, or this PIRP cannot be initiated because moratorium applies. Although the law position was also very clear earlier, the moratorium applies on the debt. And in case of personal insolvency, there is no correlation with the debt as defined in the IB code. So we have two cases in the NCLT on the same footing. And there is also enclave ruling on that. Now the definitions and clarifications, section 327A has been inserted new. This is the new section. Previously, what was there? There was no definition of registered valuer. Now, they have given the definition of registered valuer, which will have the same meaning as per provisions of the Companies Act, as per Chapter 17. And this gives the clarity for valuation professionals operating under IBC. Actually, previously there was no definition of registered valuer. So this addition is a welcome step. Section 331, security interest. Now the security interest definition was very broad. If you are having a loan agreement or any other agreement, or it is registered with the ROC, your security is registered with the ROC, even if there is no specific agreement, then you are having security interest, or if it is provided in your loan document, loan agreement, then it will be taken as your security interest. But now it has been clarified. Security interest exists only via agreement, arrangement between two or more parties, not by mere operation of law. So the position is very clear for all of us after the amendment takes into force, that we will consider security interest only when there is a specific agreement or arrangement between the two or more parties. Now we cannot view that the security interest exists merely on the basis that it is registered under the Companies Act in MCA, or it is registered with any other body. We cannot go into that. We will require a specific agreement or arrangement. So, what would be the benefit? It prevents statutory charges lines from being treated as security interest under IBC. Now, new section 331A has been added. This is a very demanding amendment. No definition of service provider was given. Friends, we all are aware, we know that in the inspection and investigation regulation, in the definition of service provider, well, there was no definition of service provider previously. If the IBBI initiates any action against the information utility or the IPA, then they were appealable to the Honorable NCLAT. But this facility was not available to the insolvency professionals. So the orders passed by the IBBI was not appealable. So only option left was to file the writ before the Honorable High Court. And the different high courts have taken different views, but the Honorable Supreme Court provides ruling, the decision given by Supreme Court in 2-3 cases. They say that in writ, High Court cannot review the decision or or the detail, cannot go into detail of the charges leveled against the RP. They can only see the decision making process, not the decision itself. So the IPs were in a deep difficulty, because if there has been something wrong at the DC level, then there was no authority to hear the merit of the cases. Now we welcome this amendment. Now the definition of service provider has been added, which will include the insolvency professional also. So now any action against the IP shall be appealable to the Honorable and CLAT. So, and after Honorable and CLAT, we may go to the Honorable Supreme Court. So this is a very good step. So now everywhere, previously they were writing the insolvency professional IP is IU. Now they have in entire act and in the regulation as well, they have provided, they have given only service provider. And the service provider has been defined under section 331A. Section 52A. Avoidance transaction. Generally, we were using this word that avoidance transaction application is pending and this is pending, but it was not defined in the Act. Now they have defined, and now they say that avoidance transaction means transaction under section 43, 45, 49, and 50. And section 66 proceedings are separate. Fraudulent trading and fraudulent activities. It is not the avoidance transaction. In avoidance transaction, we have only covered section 43, 45, 49, and 50. So it codifies the term used across the code into a defined expression. So now in the entire code, they shall be mentioning the avoidance transaction application in the code as well as in the regulation. Section 526 resolution plan. अब now in explanation, previously it was there that resolution plan may include the restructuring of the CD by way of merger, amalgamation, demerger. Now they have modified it. Actually, in the home buyer cases, we have seen, or in case of a company who is having its factory at multiple locations in the country, so it was very difficult to have a single resolution plan for all the projects or all the factories. So it was very difficult. So Honorable Anclet in several decisions had allowed the RPs to take the resolution plan separately for different projects. But the law position was not very clear earlier. Now they have clarified that now resolution plan includes sale of one or more assets of the CD through one or more plans by one or more resolution applicants. So now if we are having 4 projects, so we may have different resolution plans for different projects, and we may also invite for the company as a whole, and after that the technical evaluation will take place, and naturally the highest value will get. But it is a very good step clarifying the ambiguity in the process. Previously, we were required to approach the honorable tribunals for permission, etc. But now the issue has been resolved. Section 7, Financial Creditor Application Reforms. So original provision was there. Section 7, subsection 4 was having a proviso. I am reading that proviso. provided that if the adjudicating authority has not ascertained the existence of default and passed an order under subsection 5 within such time, it shall record its reason in writing for the same. So it was having a proviso like this. Subsection 5 was there under section 7. A learned A could admit, reject with broad discretion, and no specified timeline was there. So no mandatory recording of delay reasons. Now the proviso to section 4 has been omitted. Subsection 5 substituted. Now it provides that learned A must pass order within 40 days. Admit if default occurred and application is complete. Reject if default not occurred or application is incomplete. In this, friends, now the learned A is required to see only two aspects, debt and default. Only two aspects have to be seen. There is a debt, there is a default. Naturally, it must be over the threshold. Now, if you are having a debt or default, and even if you are going to file your application under section 9, you have to register your default with the information utility. Actually, we have covered this aspect in detail in the regulation, and there are a very great challenges into it. So, in nutshell, in short, I am telling you that if a financial creditor or the operational creditor is willing to file application under section 7 or section 9, their charge must be registered with the information utility, which will prove the default, okay, which will prove the debt, and the default would be proved by way of your loan recall notice or notice to pay the default amount. So in that case, default will occur. The date of your notice shall be the date of default, okay. NPA will not be taken into that. So now, if you file the claim with the information utility, your debt amount, so the information utility will send a mail to the corporate debtor for confirming that whether this is correct or not. Default, a debt filed by the financial creditor or operational creditor is correct or not. So previously what was happening, that the corporate debtor were not responding even after 2, 3, 4 notices. So now in the information utility regulation, there has been amendment that in case there has been no reply after 3 reminders, then it will be presumed that the debt is proved. So they will issue the record of default certificate, ROD. Now, if the corporate debtor disputes it, then in such a case, they will issue the record of default for undisputed portion, and for the disputed portion they will report the dispute. So this I am discussing because all learned professionals are here. Now, for example, I am having 1 crore 10 lakh default debt amount, and I filed to the information utility, and you disputed 15 lakh. Okay, so now the undisputed amount is 95 lakh only. So with 95 lakh, I cannot file application under section 7 or section 9. I cannot file because the learned AA cannot adjudicate the dispute of debt in between the parties. This is a civil matter. You have the learned A will not see. Learned A, to complete the process within 40 days, to pass the order within 40 days, they will see only the presence of debt for which you will enclose the certificate of information utility, point one. And secondly, they will only see the default. Okay? So, for the default, your loan recall notice is sufficient. Only two things that they will see, and as per this amendment, I don't see that there will be notice and reply, then rejoinder. Nothing would be there. Now, learned A will see the debt and default and will initiate the CIRP proceeding. Okay? So, explanation is also given. I am moving cursor over here. Record of default with information utility is sufficient proof of default. So, here the word default and debt both are proved. Both shall be proved, because in debt information utility you will also file the details related to your loan recall notice as well as NPA debt. Okay, effect, impact, strict 14 days deadline on the learned A orders, narrows ground for rejection, no rejection beyond statutory grounds. Record of default with IU creates a fast track admission route for financial institutions. Increased accountability, delays must be explained in writing. Friends, in the IB code and in the definition section, we have read the word financial creditors. Now it has been modified to the financial institutions everywhere, and financial institution covers several bodies. It also covers the national housing banks, the SEBI registered units, other units. So financial institution has been defined as per the RBI Act. What is the meaning of financial institution? So now the spectrum has been widened. Okay, so this is a very important change that we had covered in the regulation part. So here so you see that the process flow is given below. You may refer the slide below. File application under section 7. A examines within 14 days. Default occurred. Application complete. Admit CIRP commences. Reject 7 days. Rectification notice. In case if any clarification or some defect is there in your application, then previously what was happening, the applications were rejected straight way without giving you any opportunity to rectify the defect. Now you will get an opportunity to rectify the defect, and you will get 7 days period. The NCLT will grant you that period to remove the defect, if any, in the application. फ्रेंड्स, यहां तक क्लियर है? My dear friends, so many eminent friends are sitting over here. If you will also speak something, it will motivate me to
Yes,
deliberate
clear,
further.
sir. It's clear, sir. It's clear.
थैंक यू सर. संदीप गोयल जी भी हैं इसमें, और भी बहुत सारे फ्रेंड्स हैं. तो फ्रेंड्स, ये ठीक है, इसी लाइन पे आगे बढ़ा जाए.
Sir, are you taking up any questions, or in the end you will be taking up any questions?
Yes, sir. We will take. You kindly note it down. Definitely.
Okay.
Because even after all these amendments, there are further challenges.
No, regarding the IU recording, Regarding the IU recording, I have some clarification. So probably
Yes,
I will
sir,
be
you
taking
note
up.
it down. Let me complete this.
Okay.
We will be talking conveniently on all the
Okay.
issues.
Thank you, sir. Thank you.
Yes, sir. Because this is the only purpose to have the session. So now you see section 9 and 10, operational creditor and corporate applicant. Section 9, the previously it was provided under subsection 3E. Okay, with the application, you have to file such other information as may be prescribed. Previously, it was there. Okay, along with application, you have to file such other information as may be prescribed. Now, amendment, what has been amendment? Changed to any other information as may be specified. IBBI now specifies. So they have specified it in the regulation, CIRP regulation. They have specified that with section 9, what documents you are required to enclose. And out of this, one of the important feature is that you have to register your debt and default to the information utility before filing application under section 9. Okay. Now it has effect shifts prescription power from central government rules to IBBI regulations, more flexible and faster to update. Now section 10, voluntary CIRP, subsection 3A, before class B of subsection 3 deleted, removed requirement for list of creditors. Actually, in case of voluntary liquidation, there were two requirements. One requirement was declaration with respect to your solvency and insolvency. That was posing a very great difficulty because that can only be assessed when the CIRP starts, whether the corporate debtor is solvent or it is not. So solvency certificate at the time of filing the application was a very difficult preposition for the applicants. Secondly, they were required to enclose the list of creditors. So this has been amended, modified. So it simplifies the application process for corporate applicant. Disciplinary proceedings. Previously, it was there before removed reference to no disciplinary proceeding pending from subsection 4A and 4B. What was subsection 4A and 4B? Under section 10, let us have a look into that. Four A and 4B. Previously, it was the adjudicating authority shall, within a period of 14 days of the receipt of application by an order, admit the application if it is complete and no disciplinary proceeding is pending against the proposed RP. Okay. So, and reject the application if disciplinary proceeding is pending. So, friends, the disciplinary proceeding starts when the so-called notice is issued to you. The disciplinary proceeding does not start when there is an inquiry notice or notice of investigation. After inquiry and after the investigation, if the so-called notice is issued, then it is treated as a start of disciplinary proceeding. And from the date of issue of so-called till the final order, which they have now specified after our intervention to 65 days, within 65 days of so-called notice, now they have to issue the DC order, whatsoever it is, and that DC provisions we shall be discussing subsequently. Now, they have said that it aligns with section 16(3)(a). Now, the IBBI to recommend RP separately when corporate applies. So, when application is filed, then the IBBI will recommend the name of RP. And I think that motive behind this is that, for example, so-called notice is issued and your process is going on and everything is running, then also IBBI may recommend you for inclusion in this till the final DC order is passed. Now, previously there was no mandatory timeline for learned A order. Now, new proviso, A must record reason. If order not passed within 14 days, they will simply record the reason that we are having a number of cases and NCLT, there is no staff at NCLT. They are working under contractual staff at the different levels. We all are knowing it. And there are no proper orders, writing persons, and everything. The government has to strengthen the NCLT at first. Without it, merely they will record so many regions. So I don't know whether it will work or not. Your suggestion, your guidance will also be required into this. One minute, friends. This slide, everyone. Now, section 9 and 10 are personal creditors and the corporate applicant. I think that we have covered this. Okay. Now, section 12A, yes, withdrawal provisions. So, originally, previously, we were having the provision that section 12A was allowing us to withdraw the admitted application under section 7, 9, and 10 with 90% COC approval. There was no restriction on timings of withdrawal, no specific timeline for learned A to pass the order. Now there has been amendment. What is amendment? Withdrawal needs 90% voting share of COC via resolution professional. Correct? Now withdrawal not allowed before COC is constituted or after first invitation for resolution plan is made. So now we cannot withdraw our application before the constitution of COC. Point number one. So meaning thereby that we have to constitute the COC. Then after that we have to put the proposal before the COC, and after COC approval we can make. Or in case we have given invitation for the resolution plan, then there is no possibility of any withdrawal. The possibility of withdrawal is ceased. Now the learned A must pass order within 30 days. So in case of withdrawal application is filed, the order has to be passed within 30 days. Mandatory recording of the reason if AA delays. In case of delay, the learned A has to record the reason. So they are trying to bind the judiciary without equipping the judiciary. Now, effect impact: prevent premature withdrawal before COC is formed, prevent late stage withdrawal after resolution process starts, balance debtor rights with creditor protection. Strict 30 days timeline creates certainty. I think that our regulator and the government would have definitely planned to equip and strengthen our judiciary mechanism so that this timeline can be followed by them without any difficulty. Moratorium section 14 and COC oversight section 21. Now, previously in the moratorium, subsection 2 and 3 was having no explicit security COT protection. There was no protection with respect to COT. Now there has been amendment. New explanation provides moratorium applies where COT seeks to initiate or continue any action against a corporate debtor under a contract of guarantee. I think this is very clear now. I am reading it again. Moratorium applies where COT seeks to initiate or continue any action against corporate debtor under a contract of guarantee. So if your corporate debtor has given a guarantee to any other body and that COT is willing to invoke the guarantee or initiate a separate proceeding, so now it is not possible because moratorium applies into that. Effect इसका क्या होगा? Guarantors cannot use guarantee contracts to bypass the moratorium. A stronger protection for corporate debtor during CIRP. Section 21(11) COC in liquidation. What was there previously? COC role ended when liquidation commenced. No COC oversight during liquidation. So we all are aware of this. Immediately liquidation order is passed. Stakeholders were being formulated based upon the new claim which we were getting in the liquidation process. Now there will be no verification and no new claim can be filed in liquidation. If someone has left filing the claim during CIRP, then only that person can file his claim in the liquidation if he has not filed in CIRP. Point number 1. Point number 2, that if there is any amendment in your claim which was filed in CIRP and admitted by the RP, then that amendment you may notify to the liquidator. Liquidator will scrutinize and if it is okay, then he may amend the claim or he may reject it. Now in the claim verification, now you can, previously we were having the claim collation that the RP can collate the claim only or liquidator can collate the claim only, they cannot adjudicate. So there was a lot of confusion. Collate means whatsoever you have given to me, I will put all these things into a box and will take the finished product out of that. Now, in the liquidation also, they have amended, which we will discuss, that now we can verify and can assess the claim also. So now, new section, COC constituted during CIRP shall also supervise the liquidation process. The same COC will continue in your liquidation. IBBI may specify additional classes of creditors to attend COC meetings. यहाँ पर एक चीज हम लोगों को आपको याद आ रही है फ्रेंड्स, in the regulation what they have provided that now the liquidator will get fee of either a monthly fee or the fee as per amount distributed, leaving liquidation cost. Okay? Or either we will get monthly fee or the fee calculated as per distribution. And they have given the chart within 6 months, so and so. Previously, it was under Regulation 4 in the liquidation regulation. Now they have given the monthly fee without prescribing the monthly fee. In CIRP, we are having the fee guideline. The minimum fee guideline has been prescribed in the CIRP regulation. But in liquidation, they have given the monthly fee. Monthly fee, who will fix? The COC. Then the COC, what COC will do? They will again invite the tenders. What monthly fee you will take? So, before the amendment, before the regulation prescribing minimum fee, it was happening in CIRP also. So previously banks were issuing tenders. So the fee level had got down to 7,500 per month. I have attended those tender meetings organized by the banks. So in liquidation, they have simply said monthly fee. What monthly fee? What is the minimum fee? Nothing has been given. So we have suggested them that either you apply the minimum fee guideline for the CIRP in liquidation also. Otherwise, such a renowned profession should not come in the open market on the fee issue. So we are quite hopeful that our regulator will look into that. Effect, what is the effect? Major shift. COC gets a supervisory role over liquidator during liquidation, applies to new liquidation and ongoing liquidation. Here it will apply to the new liquidation and ongoing liquidation where you have not filed dissolution application under section 54. कहने का मतलब यह है कि अगर आपका कोई लिक्विडेशन चल रहा है तो ये जो 28 मई को प्रोग्राम है, अगर उस दिन से इन्होंने नोटिफाई कर दिया, so whatsoever process we are undergoing in liquidation, this provision will apply and COC will work under the new liquidation process regulation and under this amended section. Also, section 19 amended, duty to cooperate extended from personal to all persons associated with the corporate debtor, including contractors. What is its meaning? Previously, the 19(2) applications we were filing against the directors, mainly against the directors, because are there any officer who is supposed to have information but he is not cooperating to the RP. So now it has been amended. And recently I am remembering an ANCLAD decision 4 or 5 days back, wherein ANCLAD has said that the auditor, the RP sought certain information from the financial auditor. Auditor simply said that I don't have all this information, it is with the corporate debtor. He filed application to NCLT, then moved to ANCLAD. So ANCLAD said that the financial auditor is independent person and he is not within the definition of personal under section 19. Now they have amended it. It will apply to all persons associated with the corporate debtor, including contractor. Meaning thereby, now you can seek information from the bank, from the financial creditor. You can also take valuation reports and other things from the financial creditors. For that, separate regulation they have already prescribed in the CIRP regulation. But now with this definition in the IB code, previously it was not there in the IB code. That's why we were facing severe difficulties. So now it has been amended that it will apply to all the persons associated with the corporate debtor. Now section 22 has been amended. Approved RP deemed appointed from the date of COC resolution itself. That is the deeming provision which we shall be discussing subsequently. Section 30 and 31 resolution plan reforms. So friends, kindly give me a 1 minute break. Is it permitted? 1 minute break, please.
Yes, please, sir. Yes, sir.
Yes, sir.
Thank you, sir. Thank you. So friends, thank you very much for permitting me. So now we are going to discuss resolution plan reforms, that what reforms have been given. We have seen the Rainbow case and other cases wherein there has been a great dispute over the security interest. The GST department or other departments were saying that my security interest is there. And in Rainbow case, Honorable Supreme Court decided in favor of the government body, leaving the financial creditors. So it posed a very great difficulty before the regulator and to the government. So now they have made amendment. We shall be covering it. Now there is another difficulty, that I am having first charge over a property and you are having second charge. So I will desire that I should be given maximum out of the recovery. And if something is left as because you are second charge holder, hence the remaining part should be given to you. So within COC there was a lot of confusion. They have tried to resolve. Now they have amended section 32BA. This is the new section. The financial creditor who don't vote in favor of the resolution plan, dissenting financial creditor, must receive at least the lower of their liquidation value under section 53 or their proportionate share if plan distribution follows section 53 priority. इस दोनों में से जो भी कम होगा वो उसको मिलेगा जो डिसेंटिंग फाइनेंशियल क्रेडिटर है. ये क्वेश्चन आप लोगों के पास बैंक से भी बहुत आएगा, अभी आना शुरू हो जाएगा. हमारे पास तो आ चुका है. आई हैव ऑलरेडी started receiving inquiries from the banks. So this is the correct law position. Section 32D, it has been substituted. Resolution plan must provide for implementation and supervision via a committee consisting of RP insolvency professional, creditor representative and resolution applicant. Now, previously, there was no definition or no mentioning of the monitoring committee in entire regulation or in the act. This was created by our esteemed professionals that code provides that resolution plan must have a provision for implementation and supervision. So who will do it? So our professionals created a concept of monitoring committee. So that monitoring committee was put into the resolution plan, and in that certain resolution applicants were providing that they will nominate 2% from their side, 2% from FC side, and moreover, they may appoint any other insolvency professional other than the RP. If you are RP, so the resolution applicants were writing previously that I may appoint any other insolvency professional except RP. And some were writing that they will appoint the RP as a chairman. So there was no provision in law, no provision. This was out of our expertise, our professional expertise, that we put this monitoring committee concept in the market. Now they have provided specifically, resolution plan must provide for implementation and supervision via a committee consisting of RP, insolvency professional, creditor representative, and resolution applicant. They have provided it. So now the RP may or may not be there. Some other IP may be taken into it. Section 31(1) split approval. New provision has been added. A must first approve implementation of the resolution plan. That the resolution plan has to be implemented immediately, and then separately approve distribution within 30 days of implementation approval. Why it was required? There was a lot of dispute with respect to distribution. And if you have filed the application for approval of the resolution plan, and some financial creditor filed IA that the distribution mechanism is not proper and it is violating my interest and so on. So till that IA was disposed, your resolution plan application cannot be decided finally. So now they have splitted it into two parts. Learned A will immediately approve implementation. Plan is implemented. Okay, the plan is implemented. What is the meaning of implementation without distribution? This we have to see. And separately approve distribution. In how much time? Within 30 days of implementation approval. So it will give effect to allow operational reboot to begin with distribution details are finalized. Prevents delays. Section 31(2) a timeline. Learned A must pass order, approve or reject the plan within 30 days of receiving the resolution plan and must record the reason for delay. Effect, a strict timeline prevents A-level bottlenecks in the approval process. यहाँ तो हम लोगों को पता ही है कि 3-3 साल से प्लान पड़े हुए हैं लोगों के, अप्रूव ही नहीं हो रहे या और भी उसमें दिक्कतें चल रही हैं. तो उसमें क्या है कि द resolution applicant and the financial creditor both lose their interest. And in one case, I remember that was the case name I am missing right now. So in that case, a resolution plan was approved for rupees 350 crore. and it took 3 years. Then the resolution applicant said that now every asset has been depleted. At that time, I have given the offer of 350 crore. Now I will not go into it. So I am withdrawing my offer. NCLT says you cannot withdraw because there has been a contractual agreement in between you and the COC. Contract cannot be withdrawn one-sided. He filed appeal to NCLAT. NCLAT also upheld the same version. He filed appeal to the Honorable Supreme Court. They also uphold the same position. So you see that if the timeline is violated in such a manner, and not because of us, because we have to work strictly as per timeline. Even we have to call the meeting within 48, circulate the minutes within 48 hours, file several this forms to the IBBI timely. Otherwise, there will be disciplinary, maybe disciplinary. So in disciplinary orders, you say they have mentioned that there is a delay of so many days in filing the forms and everything. So we are regulated in the strict timeline. But the financial creditors and RAs we are facing. So they have tried to do it. Let us see what happens practically. Section 3156, a new section has been incorporated. That is a very welcome step. License permit clearances associated with approved resolution plan shall not be suspended, terminated if CD or resolution applicant complies with the conditions. Upon approval, prior claim against CD extinguished unless that person guarantor joint liability. तो guarantor की liability तो एक अलग चीज हो गई. तो previously also the resolution applicants were writing in their resolution plan that upon approval prior claim against CD extinguished, and a section 32A 2 was also introduced in the IB code, which prevented that no prior claim or anything will exist against the CD. Now they have specifically provided into it. So its effect would be the regulatory continuity for resolution applicants, no license suspension risk if complaint, clean slate for resolution. तो अब ये नहीं है कि भाई अब मान लीजिए कि कोई लाइसेंस खत्म हो गया है, तो वी विल कंप्लाई विद देयर डॉक्यूमेंट्री रिक्वायरमेंट्स एंड अदर रिक्वायरमेंट्स, एंड दे are required to validate it. So this is the object of this amendment. Because there are several projects which are license based, permit based, means mining lease or coal lease or excavation lease. So these are medical colleges, dental engineering colleges, they all are approval based, government approval based projects. So now it cannot be suspended or terminated. So there has been a number of litigation before the Honorable NCLT and CLAT into that, and there had been number of orders. Liquidation process, major reforms. Section 33, CIRP restoration. Now you see, friends, there is a situation that you, after the approval of the resolution plan, filed it to the learned A. Okay. In the meantime, Mr. Bhatt approaches you and says that in your approved resolution plan, approved by the COC, approved resolution plan, the RA was paying 100 crore. Sir, I will pay you 150 crore. Give me an opportunity. So you were having no option at that time because the process is closed. You have already filed the approved resolution plan to the Honorable NCLT. Nothing can happen. And there are a bundle of orders of the NCLT and the NCLAT that once the process is completed, no new person can be joined. If he has not joined the process from the initial level, since EOI and RFRP level and other levels, so no new person can come and say that I am bringing more offers. Bindal sponge case is also there into that, in which the application was dismissed. Now there is a provision. What this provision? The new subsection 1A has been added to section 33, which prescribes that COC with 66% vote can apply to the learned AA to restore the CIRP instead of going into liquidation. So, in case you have filed for the liquidation and someone approaches you that I am ready to resolution plan, or some other person approaches you with such improved offer, then you may restart your CIRP from the stage of EOI again. So the stage from where the CIRP shall restart will be your prayer part. And that will be mentioned in the order that from which stage your CIRP will be restored. So even if you have filed application for the liquidation or approval of the resolution plan, you may proceed into that. So the maximum time period is given 120 days. So within 120 days, you have to complete the restored CIRP process. Effect second chance mechanism before liquidation. COC can rescue the CIRP post deadline, avoid automatic liquidation in suitable cases. Here they have mentioned the liquidation only. But to my view, in case you are having some improved resolution plan also, so you may go to the NCLT and may start the process from the EOI level, and within 4 months you can complete it. Section 33 dissolution option. The COC under section 33(2) can now also dissolve the corporate debtor directly, not just liquidate, subject to specified conditions. Friends, in that there is clear and clear order. It was not in the law, but there is a clear and clear order, and we have faced two orders in our favor. I was arguing the matter before the Honorable NCLT. So when my COC is not ready to bear the cost, there are no assets, nothing is present, then by taking the benefit of the Honorable NCLT order, I took advantage from the NCLT and straightway went to dissolution without any liquidation. That I have faced. So now they have specifically provided in the law. So now it will resolve all the problems. So its effect is avoids costly liquidation when there are no assets worth pursuing faster closure. Section 33 moratorium in liquidation. New subsection 4. A must declare moratorium like section 14 upon passing liquidation order, preventing legal proceeding against the CD during liquidation. I don't think that previously also there was a moratorium in liquidation under section 33 subsection 5, which states subject to section 52, when a liquidation order has been passed, no suit or other legal proceeding shall be instituted by or against the corporate debtor. So technically it is moratorium only, but now they have specifically provided like in CIRP, the moratorium is declared under section 14. Now the same type of moratorium has to be given under section 33. It will stop the creditors from racing to court during liquidation orderly process. Section 34(1), liquidator appointment. A must now refer to the IBBI for recommendation of insolvency professional as liquidator instead of directly appointing the RP from CIRP. So now the RP conducting the CIRP cannot be appointed as liquidator. They have provided in the regulation very clearly. So at first of all, if you are RP, you cannot be liquidator. Point 1. Point number 2, for appointment of the liquidator, the IBBI will recommend the name or the panel system which they have adopted. So the NCLT will take from the panel as far as I understand. But I view that in case you are moving the application for liquidation, and in that application only, if the COC has proposed the name of any new liquidator instead of RP, then that liquidator has to be appointed by the NCLT. Because 2 days prior, there is a judgment in which the COC has recommended the RP, but the NCLT did not appoint that RP, appointed another RP from the panel. The order was challenged before the Honorable Enclave. Honorable Enclave said that the NCLT cannot force its decision over the COC decision. So COC once decided, it has to be implemented. So if the liquidator is proposed by the COC, then he has to be appointed. As per latest Enclave ruling also, and the intent of lies also in the same pace. Section 34A, this is the new section. Committee of creditor with 66% vote may replace the liquidator with another insolvency professional at any time during liquidation, subject to AA approval. So, what is the rationale behind it? COC gets control over liquidation performance. Accountability of liquidator to creditors enhanced. Actually, in the IB law and in the regulation, the insolvency professionals, they are doing one of the best work which they can do as a professional person. The problem is coming from the suspended director, from the COC. COC does not approve, or their approval takes time. So in the liquidation process regulation, although that is not the today's topic, but if you refer to that in the proposed regulation, that the valuer has to be appointed within 7 days. Okay, agreed. Now within 7 days, the first COC meeting be called in liquidation. I am talking in liquidation. In liquidation. Okay. And in that COC meeting, the approval of valuer has to be taken. Matlab means remuneration, not approval. Remuneration has to be approved. Now you see that within 7 days I have to appoint. Within 7 days I have to take approval from the COC. I appointed, COC did not approve the fee or any other thing, or they reject, then what would be the position into that? So there is ambiguity, still it persists. So a liquidator can be replaced, no problem. There must be certain set of guidelines for the COC also. They are approving fee, but they are not paying it. They are not approving. They are delaying the payment. What RPR liquidator will do? From where he will pay to the security agency, from where he will pay to the advocates who are discharging their duties and handling multiple applications. So, where it is addressed? It is addressed nowhere. open-ended situation has been left to us. Again, we shall be facing those issues. And when we deliberated those issues with the IBBI officials, then they said, leave the assignment. This is not the proper reform, proper answer. But once you will start leaving the assignment in case you are not being paid or there is a huge delay and you are incurring expenditure from you only. So in that case, you leave the assignment. Okay. If I leave the assignment and you join, same situation you will also face. So the process will never end. So meaning thereby, there must be strict guidelines for the COC also, although the IBBI has issued guidelines 2-3 years back, I remember. But who is following it? And IBBI is having no control over the COC. COC is regulated by the RBI. So likewise, in case of this PMLA, they have entered some arrangement with the enforcement directorate related to attachment. We are aware on that. Likewise, they may have some understanding with the RBI and get a notification from the RBI that in case of liquidation and CIRP process, the COC must follow these things strictly. Then the problem would be solved. Otherwise, it will go on. Okay. So section 35(2), it has been substituted. COC shall supervise the conduct of liquidator by the liquidator in the manner as specified by the IBBI. So we don't have any problem if the RPs are supervised, and rather there must be a healthy practice for such a supervision because RP and liquidator are experienced professionals, master in their trade and businesses, master in their respective fields. So if they are being supervised, then there must be a definite set of guidelines for that supervision also. फ्रेंड्स, यहां तक समझ में आ रहा है?
हाँ सर, समझ तो आ रहा है. You are explaining very well, but I am practically asking you because now the timeline has also been fixed for the adjudicating authorities also, and they have to record the reasons.
Yes.
But practically, what is going to happen? That is again going to be a directory for them or mandatory for them.
Actually, the Honorable Finance Minister in the Parliament, she said, it is recorded, you may see to it, that we don't wish to bind our judiciary, but for the timely process, and we have given a mandate that they must complete or record the reason. The rationale behind it appears to my mind is that they have to record the reason now. Okay. So that reason should be consolidated and would definitely will go to the ministry. Ultimately, ministry is a regulator. They are appointing the judges and everything. So when they will see what is the problem, why the reason is there, what are the reasons for the delay. So in that scenario, they will resolve. But as a professional, this is my personal independent view. Till the NCLT benches are strengthened with the proper staff, proper infrastructure. अभी भी कोर्ट जो है 2 टाइम बैठ रही है और एक बेंच सुबह, एक बेंच शाम को. मैटर इतने इंपॉर्टेंट मैटर्स 4 डेट निकल जा रही हैं, बिल्कुल नहीं आ रहे हैं. और PIRP का तो पता नहीं क्या है कि भाई PIRP is there. It is never heard. As per administrative directions, they have to list the new matter at the top, then resolution plan, then liquidation plan, then PIRP, then dissolution. My 3 dissolution applications are pending since the last 4 years. So you see that, and we are engaged. Actually, till we are discharged, the case would be counted in our list. And we can handle only 10 cases. As per new regulation, it was also previously, 10 CIRP cases. Now they have added liquidation also into it. So 10 CIRP and liquidation we can handle. And dissolution application is pending. So in that case, we are not discharged, that would be counted in our case. These are the problems we have suggested to the IBBI through the institute and directly also. So I continue meeting with them on a regular basis. And there is one more problem, which is a very alarming situation for all of us, though I will cover it subsequently. लेकिन अभी दिमाग में आ गया. If your any disciplinary order is there, okay, and disciplinary order is there and you filed appeal. So previously there was no appeal provision. So you file to the High Court. High Court grants you relief. For example, you got the favor, but no bank is going to impanel you for life. Be sure into that. You will not be impaneled, and if you are impaneled, then few banks will put you in the depaneled list immediately on the issue of DC order, even though you have got all favors from the Honorable High Court. They will not do. They are not doing actually. So this issue we have raised before our regulator. So they have said that what can we do into it? You can suspend, but you cannot do anything. How it is possible? You have to do. So let us see what happens. You are totally correct. We have to see it is not practically possible. Simply writing execution is important, not writing in the law. हम कानून में कितना भी लिख दें कि बाईं तरफ चलना चाहिए और लाल बत्ती पे रुकना चाहिए, लिखने से नहीं होगा ना. जब तक उस पर स्ट्रिक्ट कंप्लायंस नहीं होगी, एग्जीक्यूशन नहीं होगा. पेनाल्टी प्रोविजंस होंगे तो पेनाल्टी प्रोविजंस प्रैक्टिकली अप्लाई हो. अभी तक स्पेशल कोड तो है नहीं, तो फ्रॉम वेयर यू विल गेट द पेनाल्टी प्रोविजन इन्वोक. खैर चलिए आगे बढ़ते हैं. एवॉइडेंस ट्रांजैक्शन स्ट्रेंथेंड फ्रेमवर्क. ओरिजिनल प्रोविजन क्या था? 43-46 प्रेफरेंस पीरियड कैलकुलेटेड फ्रॉम इंसॉल्वेंसी कमेंसमेंट डेट, going backward. So we are aware that our look back period for preferential and this fraudulent or extraordinary transactions, okay, it was 2 years and 3 years. 2 years, 3 years in case of related party and 2 years in case of normal course. Okay, 2 years and 3 years.
So 1 year and 2 years. Sir.
Acha, 1 year, 2 year. Okay. 1 year, 2 year. Correct. So now, from which date that period was required to be calculated? From the insolvency commencement date. तो जो इंसॉल्वेंसी कमेंसमेंट डेट है उससे पहले जा सकते हैं. अब it will be calculated from the initiation date. So when the application is filed, so we will have the look back period of 1 year, 2 year from the initiation date, not from the insolvency commencement date. Now you see that as per new amendment, the application has to be decided within 14 days. I think, yes, 14 days. Resolution plan in 30 days. So if application is going to be decided in 14 days, तो हमारे लिए तो 14 ही दिन बढ़ा, और तो कुछ बढ़ा नहीं. So समझ में आया नहीं, मेरे तो नहीं आया, बाकी आप बताइएगा. Section 47, only RP liquidator could apply for the avoidance. This is a very important for all of us. Now, for previously what was there, कि only RP and liquidator was required to file application under section 47. So now, in case RP and liquidator fails to file such avoidance transaction application, then in that case, the COC member or partner, matlab any member of the CD or the creditor or COC may independently apply to the learned AA. Directly they may apply. और अगर उन्होंने अप्लाई कर दिया तो डेफिनेटली आपके ऊपर डिसिप्लिनरी एक्शन होगा. दे हैव प्रोवाइडेड इन द लॉ इटसेल्फ. 100% होगा डिसिप्लिनरी प्रोसीडिंग. Extraordinate credit period calculated from 2 years preceding insolvency commencement date. ठीक है, अभी इनिशिएशन डेट पे से हो गया. डिटेल्ड क्लेम कोलेशन प्रोविजन एंड लिक्विडेशन नाउ इन सेक्शन 35 and COC mandate. The detailed claim provision given in the liquidation has been omitted. Section 3842 related to claim verification and everything has been omitted in the liquidation, in the governing to that. It has been omitted. Now the claims are handled as per section 35 COC mandate. तो इस साइड में आप देखेंगे एक्सट्रीम राइट में इफ आरपी थर्ड वाला आप टिक देखिए. इफ आरपी लिक्विडेटर फेल्ड to report despite having information of avoidance or transaction, then A must to direct IBBI to initiate disciplinary proceeding. Must to direct. तो लर्नड ए के पास भी ऑप्शन नहीं है, उनको डायरेक्शन देनी ही पड़ेगी.
Sir, you are in mute, sir. You are
Sir,
in
you are
mute.
in mute, sir.
Sir, yeah.
So, Sandeep, you are in mute.
We can't hear you, sir. Mr. Bhatt, we can't hear you.
Sir, you're on mute.
Now my voice is clear, friends?
Yes, sir.
Okay. Sorry. There has been some error. Okay. Kindly give a minute. Yes, friends. So now you see that these sections have been omitted. Section 38 to 42, claim collation and verification during liquidation. 5 sections have been omitted. Why it has been omitted? Now all the claims filed in the CIRP shall be carried forward in the liquidation. So no new claim can be filed in the liquidation. If only those claims can be filed in liquidation if they are not filed in CIRP. Chapter 4, Section 55 to 58, fast track CIRP for small entities. Now it has been omitted. New section replaced by new chapter 4A, creditor initiated insolvency resolution process. इसका brief ये they have covered it in detail in the regulation. From the date of passing the resolution by the creditor, RP is appointed and RP will start functioning. That we will cover subsequently. And section 74, criminal penalties for contravention of moratorium resolution plan. Now it has been replaced by section 235A, civil penalties, and new section 67B, specific moratorium plan violation. तो इसको इन्होंने section 76, criminal penalties has been replaced by the civil penalties. अब ये जो इन्होंने न्यू पेनाल्टी प्रोविजंस डाले हैं विच आर विजिबल ऑन योर स्क्रीन, सेक्शन 64A, 67B, तो पेनाल्टी हैज बीन इंक्रीज्ड फ्रॉम 1 lakh to 2 crore in all these contraventions, frivolous or vexatious proceedings before a contravention of moratorium, operational creditor concealing dispute, full payment in section 9 application, frivolous vexatious proceeding before A under part 3, personal insolvency, general contravention. Now this judgment power has also been given to the disciplinary committee. One thing is very important to bring to your kind notice, that previously what was happening, that due to act of the RP or liquidator, some third party has gained a very good benefit. Okay. So IBBI DC was having no power to direct that third party to make the losses good. Only RP was charged or liquidator was charged. Now the DC will also be having power whenever you will see the amended inspection and investigation regulation. So now they are having power to issue direction to the third party to make the losses good. And restitution power has also been given. A form has been prescribed. If I was beneficiary and due to act of the RPR liquidator, some third person has got the benefit, then I will file my claim before the IBBI and they will reimburse me by taking those funds or those benefits from that third party. So this is good. Now the CIIRP, which has been introduced new, that is chapter 4, who can use it? Who can file application? Section 58A. Corporate debtor with asset income below notified levels, specific creditor classes or other notified categories. Not applicable if CIRP liquidation underway or if CD underwent CIRP or CIRP in last 3 years. So, who can apply into that? With asset income below notified level, this they have described in the regulation. Specified creditor classes or other notified persons, only they can apply. What is the timeline? 150 days from commencement date. So this process has to be completed within 150 days, extendable by 45 days, once only, with 66% COC approval. If there is no resolution plan, then learned A passes conversion order. Conversion order means regular CIRP starts. If no resolution plan is filed within 150 days, then it will be converted to the regular CIRP. मैनेजमेंट किसके पास रहेगा इस प्रोसेस में? मैनेजमेंट stays with the board of directors. RP attends meeting and can reject resolutions passed in violation of CIR IP provisions. So only the RP during this CIRP provisions, he will seek whether the resolutions being passed are in alignment with the IB code and regulations made. If it is not, he may reject the resolution by giving the reasons. And the learned A will also convert it into the regular CIRP if the process given in the regulation to initiate CIRP is not followed. So two instances are there. If the process enumerated has not been followed, then it will be converted to regular CIRP. Second, within 150 days, no resolution plan is filed. In both the cases, it will be converted to CIRP. Who initiates? It will be initiated by a financial creditor from a notified class or financial institutions. Must get 51% creditors approval, give 30 days notice to CD for representation, then appoint RP directly, no learned A admission required. Process क्या है कि जो notified financial creditor and financial institutions, so whatsoever I had told you earlier that financial institutions have also been covered. So that is going to widen our scope. And they will pass a resolution, 51% creditor approval must be there. Now if I am a financial creditor, I don't know that who are other financial creditors. That search I have to make. And I have to invite all the financial creditors and I have to initiate. Generally, I don't think that which bank is going to take initiative, such a vast initiative, that he will invite other creditors, will organize meeting, will get 50%, 51% approval. And after its approval, that FC will give notice to the CD for its representation. Then when representation is arrived, then new meeting will be called and that representation shall be put to that meeting. And even after that, it is resolved by 51% vote to initiate CIIRP. Then they will appoint the RP by passing a resolution only. And RP will start functioning immediately on passing the resolution. So moratorium, optional moratorium, RP applies to the learned A with COC approval. Moratorium starts from the date of application, not admission. A may confirm or reject based on process needs. So in that case, when the RP is appointed by the creditors, financial creditors, then the moratorium does not apply automatically. For that, the creditors have to pass the resolution and RP has to apply to the learned A, but moratorium will start from the date of application, and finally it will be confirmed by the learned A, who may also reject your moratorium request. Withdrawal of application. For withdrawal, 90% COC voting share shall be required. Not allowed before COC constitution or after first invitation of the resolution plan. The learned A must pass order within 14 days. Applicability, जितने भी अपने duties, responsibilities, calling of the COC meeting, voting, all these provisions shall apply to this also. Our power, duties, approvals under section 28A. Without specific approvals, we cannot proceed under section 28. So that we have to comply. Group Insolvency Framework, section 59A. A completely new chapter enabling coordinated insolvency proceeding for corporate groups. Rules will be prescribed by central government and the required parliamentary approval before notification. ये अभी pending है. अभी rules has to be prepared and parliamentary approval is also required before notification. It will apply from the date of notification. A common bench is proposed for that, for group insolvency. A single NCLT bench for insolvency proceeding of all group companies pending proceeding transferable to this common bench. So if several applications are pending, it will be transferred to one common bench. Group COC, formation of a committee comprising COCs of all group entities फॉर ज्वाइंट डिसीजन मेकिंग. इससे पहले हम लोग ये समझ लें कि ग्रुप का मतलब है क्या. व्हाट इज द मीनिंग ऑफ ग्रुप. सो यू मे सी द बॉटम ऑफ द स्लाइड. ग्रुप मीन्स 2 or more corporate debtor interconnected by control or significant ownership, 26% plus voting right. It includes holding, subsidiary and associate companies as per provisions of the Companies Act. This is the meaning of the group. Control or significant ownership, 26% plus voting right. And it will include the holding, subsidiary and associate companies. The group is very clear. Coordination. Now, coordination between COCs, IRPs, RPs and liquidators of different group entities for synchronized resolution. एक अलग अलग कंपनीज के अलग अलग आरपीज हैं, लिक्विडेटर है, अलग अलग सीओसी है. अब वो सारे ग्रुप एंटिटीज जो इस डिफिनेशन में फॉल कर रहे हैं, दे विल बी ट्रांसफर टू ए कॉमन बेंच and there must be coordination between all the IRPs, RPs and COCs. So for that, a binding agreement shall be made. What is this? A coordination agreement may be approved binding on all participating group companies, their COCs and enforceable by the AA orders. So for that purpose, you will appoint a coordinator in between you or some FC or some RP having the major stake shall take a lead. He will invite the meeting, and in the meeting he will discuss the coordination agreement terms. That coordination agreement shall be approved by all the majority of the group members, although they have not given the voting percentage into it, that the 66% of the entire group or whatsoever it is. For that purpose, we have to refer to the regulation. But in my view, it will be 51%. It should be 51%. Common IP. Appointment of a common insolvency professional to facilitate coordination across the group insolvency proceeding. तो इन सारे आरपीस और इसके अलावा एक कॉमन insolvency professional shall be appointed. But the problem which I foresee, that who will initiate all this? I think that the RPs of the company having major stake or some FC has to take a lead and call the meeting, then coordination agreement, then finalize the name of a common IP, then his appointment. So cost of coordination measures may be treated as insolvency resolution process cost. So ये coordination measures की whatsoever cost is there for coordinating all these, it shall be the CIRP cost only. Kindly give me 1 minute break, dear. Is it permitted?
Yes, sir.
By
Yes,
friends?
sir. Please go ahead.
Thank you. Friends, should we start? And thank you very much for permitting me.
Thank you, sir. Thank you. You are
Thank you.
speaking for last 2 hours continuously.
एक्चुअली सर जब इंस्टीट्यूट में रीजनल काउंसिल मेंबर थे, चेयरमैन थे, तब तो बहुत प्रैक्टिस थी 11
नहीं
से
नहीं
19 तक. अब
no, no,
इतने 3 घंटे.
everybody needs 1 or 2 minute break after an hour. 40 minutes के बाद ही हो जाता है rather.
सर
Attention span scientifically is for 40 minutes only.
yes.
For our student also.
We are in such a profession that we have to be a student always.
Yeah. Thank you, sir. Thank you.
Thank you, sir. Thank you. So, friends, now we are covering voluntary liquidation, cross-border insolvency, and e-portal in brief. So, voluntary liquidation, section 59, timeline capped. Now, the voluntary liquidation must be completed within 1 year. And in the liquidation has to be completed within 180 days, as I memorize, as per new amendment. Termination right. After commencement, members may pass a special resolution to terminate voluntary liquidation with a 2/3 creditor value approval within 7 days. So, previously, once the voluntary liquidation was initiated, then there was no provision to terminate it. So now there is a provision that if the special resolution is passed by 2/3 creditors, then the voluntary liquidation initiation may be terminated by filing, and after that application has to be filed to the learned AA. Liquidator must intimate IBBI and ROC within 7 days of resolution and approval. Termination is effective from the date of intimation to ROC. So immediately the RP liquidator intimates to the ROC, the termination takes effect. Claims during liquidation, section 18, chapter 2, claim collation provision now apply to voluntary liquidation as well. So now the claim collation, previously it was not there, now it applies to the voluntary liquidation. So we have to collect the claim. And now as per the amendment, we have to verify and assess the claim also. So quantify the claim also. Previously only collation was there, but now we are empowered to quantify it also. So cross-border insolvency, section 240C, central government empowered to prescribe rules for cross-border insolvency proceeding under IBC. And for that purpose, we have to give recognition of foreign proceedings, granting relief, judicial cooperation and coordination. And for that, our government has to enter agreement arrangement that we will also cover what is the problem into that. So they have to enter several agreement and understanding with different foreign governments that order passed by their court shall be recognized by us, and order passed by us shall be recognized by their court. So in one Singapore proceeding, I was appointed RP in one PI case here in India, and someone initiated PIRP provision as per Singapore law in Singapore against the same personal guarantor. So I immediately made the arrangement and filed my application that I am appointed RP in India. So the Singapore court terminated their application on this ground. So I view, although I am not aware, that our government will be having some arrangement with the Singapore government. So that has to be framed actually, applied to specified debtor class involving specified countries and territories. So but natural है कि जब तक ये bilateral agreement arrangement नहीं होगा different government से, so it has to be notified. So we have to see what notification would be there after they enter arrangement with different governments, different countries. Rules may modify IBC Companies Act provision for effective implementation. Designated benches may be created for cross-border. Rules require parliamentary scrutiny laid before both houses for 30 days. तो ये भी होना है, सेक्शन तो ला दिया है लेकिन इट हैज टू बी डन. Electronic portal, section 240B, central government may provide an electronic portal for insolvency and bankruptcy processes. All specified procedures shall be carried out through this portal only. Aims to digitize and standardize the insolvency process end to end. Reduces paperwork delays and in-person requirement. So as we know that in liquidation they have also done auction through banknet and some platforms they are providing. Now they are in the process of creating some uniform portal or some unified aspect wherein we will do all the act related to insolvency and liquidation into it. So that they are developing, that is good. That will help us also. And maybe that we are filing different sets of compliances to the IBBI. So they may evolve a system to take the extract from that portal for their purpose. We need not to file reports separately and then facing disciplinary on that ground. Personal insolvency and bankruptcy key amendments. Section 96, moratorium individual. Inserted subsection 4, automatic moratorium under section 96 does not apply where application is filed for initiating insolvency resolution in respect of a personal guarantor to a corporate debtor. So automatic moratorium जो 96 में था वो ऑटोमेटिक अब नहीं अप्लाई होगा. ठीक है, जो पहले हो जाता था इमीडिएटली आफ्टर फाइलिंग द एप्लीकेशन. सेक्शन 99 रिजोल्यूशन प्रोफेशनल रिपोर्ट. Previously we were required to file our report under section 99 within 10 days. Now it has been amended to 21 days. Section 106 repayment plan meeting. So there had been a lot of confusion before the NCLT benches. We were filing, there is no repayment plan. We were filing our report under section 106, and 106 proviso provides that in case no repayment plan is received, the RP shall record the reason, record it, and also record the reason for not calling the creditor meeting and shall file the report. But they were not considering, a lot of confusion was there. Now they have specifically provided. That is good. New subsection 1A, if no repayment plan submitted within stipulated time, then the RP will report to learned A. A will terminate the insolvency resolution process. Debtor creditor may apply for bankruptcy. New subsection 3A, for personal guarantor to corporate debtor, RP must summon creditor meeting by written notice specifying date, time and place. Whether or not we have received the resolution plan, we have to call a creditor meeting. If we have not received, we have to inform them, minutize the proceedings and file our application under section 106(1)(a) that we have not received any resolution plan. Creditors have been informed. The minutes of meeting is enclosed. So now the learned A will terminate the insolvency process. Section 121, bankruptcy order. New class D. Bankruptcy order can also be passed where A has passed a termination order under new section 106(1)(a). So in this process, how directly the bankruptcy order can be filed, that for that purpose we have to see the bankruptcy regulation and personal insolvency and bankruptcy regulation. So in the amended regulation, they have specified the procedure. That procedure have to be followed. So in such a situation, there may be bankruptcy order also.
Sir, can I ask you something?
Yes, yes.
So what is the impact of subsection 4 and 96?
Section 496.
Yes. Subsection 4 of Section 96. Where the automatic moratorium under Section 96 does not apply where application is filed for initiating insolvency resolution in respect of personal guarantors to a corporate debtor.
Yes, yes, yes.
What is the impact of it? Does it not make 96 redundant totally? If that is not applicable, does not apply, then 96 is only when the application is filed before admitting it.
No, if we refer Section 96,
Yeah.
1 minute.
Yes.
Section 96 is with respect to interim moratorium only.
Yes.
When an application is filed under Section 94 or 95, so the interim moratorium applies immediately after the application is filed.
Yes.
Now they have inserted subsection 4.
Yes.
There will not be automatic moratorium.
So what does that mean, sir?
No, it means the moratorium will be declared by the NCLT order only. If NCLT is finding some merit, so when they are appointing, they are appointing the RP, because at first of all, RP has to be appointed. In such a situation, if the NCLT notices that moratorium needs to be applied immediately, then they will do. And for that, we have to see the complete amended Section 96. Here I have given only subsection 4. So in that, we have to read the entire section, the modified entire 96 section. So I have covered only subsection 4. So automatic will not be there now.
सर इसमें एक बात मैं जो समझना चाह रही हूँ वो ये है कि अगर 96 वाज ऑटोमेटिकली अप्लाइंग, अब आप बोल रहे हैं कि एनसीएलटी बाय वे ऑफ एन ऑर्डर जब वो एप्लीकेशन फाइल होगा उस समय जब वो अगर एडमिट करेगा तब एनसीएलटी ऑर्डर देगा कि भाई इंटरिम मॉरेटोरियम अप्लाई कर रहा है कि नहीं कर रहा है. नाउ अगर सपोज इसमें कोई आरपी का फिर रोल होगा क्या कि सपोज अगर कि पीजी कोई एप्लीकेशन करेगा टू एनसीएलटी और उसके बेसिस पे करेगा, या फिर सीओसी अगर आपको बोलता है, फाइनेंशियल क्रेडिटर बोलता है कि भाई हमको इंटरिम मॉरेटोरियम नहीं करवाना है, तो आरपी का व्हाट, हाउ विल आरपी be involved in this process? Is there any thinking on that?
Yes, there is a thinking. What will happen that when anyone is filing application, then at first instance RP is appointed if application is complete in all respect. Okay, but on the appointment of RP, moratorium will not apply. RP will supervise. He has to file report within 21 days, and if he is of the opinion that the personal guarantor is having so and so assets and creditors are enforcing on those assets or those things, immediately RP will file application to the Honorable NCLT for declaration of moratorium, giving circumstances and fact that this is going to happen. So in that case, it will automatic will not be there, but in that case, learned A will order for the moratorium. No, it cannot be done.
सर आरपी फाइल करेगा कि पीजी फाइल करेगा कि भाई मेरा इंटरिम मॉरेटोरियम में, क्योंकि नॉर्मली सरफेसी में तो उनके पास एनकम्बरेंस रहता ही है, सरफेसी का तो वो रहता ही है.
हाँ, यस अब मैं आपको बता रहा हूँ. फॉर दैट पर्पस दे हैव गिवन कंप्लीट डिटेल्स in the PIRP regulation. In PIRP regulation, they have given how it will be done in case application can be filed by anyone, by the RP or by the this personal guarantor, and even by the other creditor. If there are 2-3 creditors, then it may also be filed by any other creditor. So for that, we have to see the details once it is notified. Right now, they have provided this. For that purpose, when the entire section and entire regulation is notified, then we will have to see the complete detail. How this will, if I want the moratorium be declared, then with what process it will be done?
Okay, thank you, sir.
Key amendments in PIRP, section 124, automatic stay. Inserted subsection 4. Automatic stay under section 124 does not apply where application is filed for bankruptcy in respect of a personal guarantor to corporate debtor. Same situation which we were discussing now. They have inserted new section 164A where debtor enters an undervalued transaction deliberately to keep assets away from creditors or to adversely affect creditor interest. Learned A may restore the position or protect victim creditors, protects bona fide third party purchasers acting in good faith without notice. So in PIRP, we don't have look back period. But now, if we find or any financial creditor or any other creditor notifies the RP or from any other source we are getting information, then we may apply, and in such a case it will be enforced. It will be enforced. कि पहले क्या होता था कि they disposed their asset in different names or in their family names. What is the look back period? That I am not clear as on today. It will be 1 year, 2 year, or if there has been any deliberate attempt to like fraudulent transaction, it may be 10 years. That we will have to see when the regulations are notified. Section 178, distribution. Clarification added, government dues. Central and state government dues, whether secured by statutory operation or by agreement for last 2 years, are distributed under priority class D. Remaining government dues goes to class E. So it resolves ambiguity on government dues priority in bankruptcy distribution. Now consistent with the liquidation rules, section 53. So, whatsoever we are having distribution mechanism in section 53, likewise in the same process, we shall be distributing the government dues in PIRP matters. IBBI powers. Section 196. Reference to insolvency professional IUs replaced throughout with service provider. New consolidated definition. IBBI can specify COC conduct standards including timelines for decisions. Levy of fee now explicitly covers all process under code. So ये जो whatsoever we were discussing, there must be some standard code of conduct after discussion with the RBI, and RBI and IBBI should jointly issue notification into that, and that is highly required. Section 219, show cause notice, substituted. IBBI may issue show cause notice to service provider on prima facie satisfaction after inspection or on record material without completing formal investigation first. This is a very alarming thing for all of us. Someone is filing complaint. What is happening as on date? Someone files complaint. We receive inquiry notice that this is the complaint against you. You file these documents, and we will do the inquiry. And if after inquiry it is found that investigation has to be done, then there will be a separate investigation order by the IBBI appointing the investigating authority. Then that authority will investigate you. And after investigation, and after taking so many details from you, if it is found that so cause notice should be issued, then that notice will be issued to you. Then in such a case, from the date of notice, the disciplinary proceeding will start. Now what they are saying? No, we will not do anything. On the material on record, if I am satisfied, I will issue you so-called directly. That has to be highly objected, because in my one friend's case, the Honorable NCLT decided on charges, NCLAT decided on charges, IBBI sent him an investigation notice. On the same set of charges, which was heard at length by the Honorable NCLT, they did not grant any favor to the opposite party. Opposite party went to NCLAT, adding some more charges. From there, they also did not get any relief. Then they filed complaint to the IBBI. And IBBI straightway started investigation without any inquiry. Although it has been replied with under our consultation. But you see that we are working for the interest of all, and even you will not ask me, and on the basis of material available on record, without any cross verification, you will issue so-called and start disciplinary without any inspection or anything. So,
Sir,
investigation process has been deleted.
Sir, can I come in, sir?
After inspection only, I filed my reply and they are not satisfied, they will issue so-called. There is no necessity now to do investigation. Likewise, section 217, 218, complaints and investigation, references updated, complaints and investigations now cover all service provider. Okay? Now we are in the definition of service provider. We can file appeal to the Honorable NCLAT against the orders of the IBBI. Section 214, information utility. Operational creditors must submit financial information to information utility before filing Section 9 application. Corporate debtor must authenticate information submitted to IU within a specified time. No response, deemed authentication. This we have already discussed. Before filing application, you have to get your debt and default registered with the IU. And with that proof, you have to file application. Section 220, disciplinary committee. IBBI must constitute one or more disciplinary committee, chairperson, whole-time member or executive director. So-called notice is referred to disciplinary committee. Penalty enhanced 2 rupees 2 crore from 1 crore. New right to appeal to NCLAT within 30 days. In every organization throughout India, including our respective institutes, the disciplinary board is a different and distinct authority. Different and distinct authority. They are neither employee of our institute, nor they are employee of any. You see, any public sector undertaking or government body, disciplinary body is different. Investigating body is within institute. They will do investigation, everything. They will collect information. They will frame charges. And if they feel that charges are grave, the matter would be referred to the disciplinary committee after so-called notice, and our replies on that. That disciplinary committee is totally different. Having 3 persons, we are having NAFRA and other committees. What is there in IBBI? The IBBI persons itself forms part of the disciplinary committee. And the investigating authority or the inspecting authority, they are working under them in different capacities. So, where is independentness? We have raised objection. We should raise. We have already raised in the portal, but they will do. And in one case, previously, if you see under section 220, only the whole time members of the IBBI can be the disciplinary committee members. And members, the word members was used. So they were constituting disciplinary committee by one member. And in one DC, the chairman passed the order. He became DC. That order was challenged at Mumbai High Court. So High Court said that in the law, it has been written that the DC shall consist of whole-time members only. Not members means two or more. But they constituted one-member committee in several cases. And in one case, the chairman itself became the DC. So that order was dismissed. The DC order was set aside, not in accordance with law. So, seeing all these high court orders, now they have prescribed it in the law. Okay, that now chairperson, whole-time member, executive director, anyone can be. Our chairperson, whole-time member, or executive directors are excellent persons. They are doing very good. We all know this. And but the thing is that why to have a critic of not being independent? The IO is your officer. Investigating authority is your officer. He is investigating, then you become disciplinary. I don't know. Rest, my friend have to see and guide me also on this. Section 214 information system. Registered valuer so now required to submit information to IBBI in a manner as specified, closing a reporting gap in the information system. That is good. So now they have to reply to the IBBI as well. Mandatory timelines introduced by the amendment. So what mandatory timeline? Section 7.5, 14 days. Admission has to be done in 14 days. Voluntary liquidation has to be admitted in 14 days. Approval or rejection of resolution plan in 30 days. Dissolution order within 30 days of application. And CIRP commencement has to be decided in 30 days. CIRP withdrawal application in 14 days. And secured creditor must inform liquidator of intent to realize security interest. That period is now 14 days only. Previously it was more. As I remember, it was perhaps 30 days. Now the section 14, section 9.5, a order to admit reject operational creditor application 40 days. A order on withdrawal application 30 days. A order on liquidation commencement. Likewise, liquidator to complete liquidation and apply for dissolution within 180 days. Now we have to complete liquidation within 180 days. However, it may be extended for a further period of 90 days if the sound reason exists. CIRP completion time 150 days. And NCLAT must also dispose of appeal within 3 months. So there is a mandate to NCLAT also. They have to decide appeal within 3 months. IBBI to refund liquidator name to A after reference 10 days. So this 10 days provision is already there in the Act. So in the initial stage, I remember that NCLT was writing to the IBBI for referral of the name. There had been no response for a period of 2 months, 3 months. To overcome this problem, now what they have done, they make a panel and give that list to the respective NCLT benches. And now the NCLT benches from that panel appoints after verifying the IBBI portal related to disciplinary action or anything. So IBBI Amendment Act impact on insolvency resolution process. So there has been CIRP reform, creditor empowerment, cross-border insolvency yet to be notified. These have been the positive impact of the resolution process. Okay, what impact we will be having in the resolution process? Time-bound completion, liquidation now to be completed within 180 days, with voluntary liquidation capped at 1 year. Now the allows business revival component of a resolution plan to commence before the distribution waterfall that we have discussed. Curbing frivolous litigation. So litigation was 3-month time limit for NCLAD to decide insolvency appeals. So this will also be given. This will also give us a good benefit. COC oversight extended to liquidation. This we have studied. Enhanced transparency via information utilities. Now everyone has to be, let me read it. IBBI mandates full disclosure of above transactions and carry forward losses in the information memorandum. Amendment to information utilities regulation strengthen record of default reporting. So now everyone has to file, and with that proof, you can file application. Government dues clarified, level playing field. Government dues are now classified as unsecured under Section 53 of the IBC, ensuring fair priority in the distribution waterfall and reducing uncertainty for financial creditors and resolution applicants. तो वो पोजीशन रेनो वाली इन्होंने क्लियर कर दी. Stricter CIRP withdrawal rules, 90% COC vote required, plus withdrawal permitted only until first call for resolution plan and after constitution of the COC. New definition, avoidance transaction, section 52A, formally defined. Avoidance transaction has been defined. Look back period clarity. Now it is from initiation date. Creditors can directly apply. In case the RP fails to report for the avoidance transactions, then any member or partner or creditor may apply. So strong accountability is there. And now the liquidator can now apply for wrongful trading. Previously it was written in the law that RP can apply. So now the liquidator also. RP and liquidator disciplinary action if they miss fraud and creditor proves it. Okay. NCLT can penalize frivolous. ये तो penalties provision है. ठीक है. 5 crore तक सेक्शन 235A में पेनाल्टी का प्रोविजन इन्होंने किया हुआ है. क्रॉस बॉर्डर इंसॉल्वेंसी फ्रेमवर्क alignment with unilateral model law enables recognition of foreign proceeding, bringing India on par with global insolvency standards, critical for multinational corporate debt resolution. So if it is implemented properly, it will be very good. Neutral IRP and anti-promoter backdoor safeguard, removal of corporate debtors IIRP nomination right, Section 10 amendment. So now the nomination right under Section 10 in case of voluntary liquidation is not there. It will prevent erstwhile promoter from influencing resolution. IBBI recommends a neutral professional for each case. So now, in case of voluntary liquidation, only the IBBI recommended RP shall be appointed. Insolvency professionals, IBBI Insolvency Professionals Amendment Regulation 25, tighten compliance standard, accountability, and ethical obligations for IPs managing CIRP state. So, what is the key outcomes? Global investors' confidence shall be boosted up. Reduced resolution timeline is there. Promoter manipulations curbed. IP accountability elevated. Home buyer interest secured. transparent waterfall distribution. IBBI governance, accountability and penalties. So this we have we can refer to so-called notice mandatory section 219. Formal SCN must precede any disciplinary action. Due process codified, reducing arbitrary action. अब जब whenever we will receive everything in finality, though our IPs have given several suggestions, we have also given, Institute has also given. Let us see what is the final outcome of all these suggestions. Anklet appeal is a very welcome step. Overall impact is there, which we have already studied. I am skipping that slide. These are the key takeaways which we have already discussed. It has been summarized. These are the key takeaways. So I have prepared another slide wherein there are certain issues which could not be addressed even after all these modifications. I am opening that slide and that I will cover in 5-7 minutes only. So is it permitted, sir? Friends, should I cover that slide?
Yes, sir. Yes, sir.
Our 43 friends are there and only one friend is interested.
Please, sir. Please, sir.
Yes, sir. Yes, sir.
Thank you, sir. Thank you, sir. Give me just 1 minute. I am opening that particular slide.
There was one question from me, sir. Can you hear me? Am I audible?
Yes, sir. Yes, sir. Tell me.
Yes, yes. There's amendment in sections 34 for RP not to get appointed as a liquidator.
Yes.
Now the application is pending for the last 4 months, and RP has given is the consent to act as liquidator. The application is not coming for hearing. In that case, what will happen?
No, you see that every section or regulation has to be notified first. So we presume that on 28th they may notify it. So it will not apply retrospectively. Your application is already pending. It will be decided on that merit. The new law, which is coming subsequently, cannot be applied to your application. Any application filed after the law is notified, so that law will apply to the new applications.
Now, under the
not
duties
the old
of
applications.
Sir, I just wanted to tell, under the duties of the resolution professional, till the liquidator is getting appointed, he will continue as a resolution professional. So, in that case, what Mr. Sukhdev has asked, till a new liquidator comes, he is bound to continue as a RP.
No. I am saying कि RP को like liquidator के लिए recommend किया COC ने.
Correct.
Now the thing is कि application को file कर दिया in September.
Application is filed, it has not come on board
6
and
months
it has
back.
not been decided.
Still,
yes,
still yes, that is what I am saying. But generally what happens, it has never come up for hearing because, as you know, next.
Sir, actually, my case is July. It was filed like a liquidation order.
These generally the members they take cognizance. Let me finish. they take cognizance of the whatever is law is being notified presently also.
Correct.
They take
Correct.
cognizance of that.
Correct.
This is what I mean to say. The member may say कि now the law has come, and as per your application, you won't be doing as liquidator. This is what I feel.
Your feeling is totally correct in case your COC your COC is not agreeable and they are willing to go by the new law, then no one can help it. They will move another application or they will file substituted RP.
That is not
But
the
in
case.
case your CEO,
That is not the case. They are agreeable. That's why they have
no,
recommended me as.
if they are agreeable, NCLT will not take suo moto action. NCLT is not going to say that new law has come. Your application is now your application will be decided as per new law. NCLT will never say. But
Sir, 1
if
minute, sir.
some COC is saying,
I doubt, sir.
Sir, 1 minute. Actually, sir, I tell you actually, Mr. Sukhdev case, same case, mine actually. Mine is still older. I filed in July. Okay. COC approved. COC appointed me as a liquidator. It was filed in July. After that, so many hearings actually, the other issues there. So the liquidation order is yet to be passed. Even as on date, yet to be passed. But
yes.
Sir, 1 minute, please listen. Last we had on May 5th, we had a physical hearing. In that, the NCLT judge stated that once the liquidation order passed, you will not be the liquidator as per the new law. So, though it is filed prior to the new amendment, they say when I pass actually, see, unless it is passed, unless you have been appointed prior to the amendment, you can continue. But now people like you and me actually are now liquidation application is filed, but order is not passed. So therefore, please don't have any hope, sir.
Sir, just want Sandeep, I want to
that has not been notified. You should have argued. That law has not been notified yet. It has received the president assent and everything. They will be notifying on 28th, I think. I presume.
Sir, it is already notified. That is one actually. The second thing
even
is
if
that
it is notified, Ravichandran sir, even if it is notified under 34A, even if IBBI appoints a new liquidator under section 34A, the COC can change the liquidator again back to you.
No, sir.
Yes.
I doubt actually.
Yes, you can with 66% voting, they can change the liquidator back.
Yes,
sir. No, sir. The intention, sir, you go by the intention of the law. Intention of the law is that some people have done some, with the wrong intention to bring the company into liquidation. That is what the underlying reason. That is, they don't want a resolution because we want the higher fees actually. So people have dragged the company into liquidation. That is the only one reason they are quoting actually. But unfortunately, sir, my suggestion, I mean, the institute can take up with the IBBI this thing. The issue is that if the company is a running company or there is a possibility of a resolution plan, I can understand. In my case, what happened, sir? The manufacturing operations stopped in 2018. That is 8 years over. There is nothing in the company. There cannot be even any resolution plan possibility because only the parent land is there. Nobody will come there actually. So it has to be sold. Unfortunately, even in this case also, one has to, the liquidator has to be changed. That is the unfortunate thing. Ideally, it should have been left to the judge actually to decide whether this RP is responsible for bringing the company into liquidation. That option should be given to the judge. But unfortunately, what happened is it's a blanket thing actually. So even there is no resolution possible, we have to get out. That is the problem actually.
Now, should I say, sir, something? Actually,
Yes,
previously there was nothing, so they came up with the circular that the RP cannot be appointed a liquidator. Some NCLT benches were recognizing that circular, and several NCLT benches were not recognizing because it was not prescribed in the law. So by way of circular, the law cannot be amended. So there were a mixed opinion of different NCLT benches. Few NCLT benches replaced and few NCLT benches did not granted any favor to that circular. What is in the internal file of the IBBI, that is one point which you raised, that by if RP could not resolve, then he should not continue as a liquidator. That is one aspect. Second aspect is that the different class of RPs should get work. This is second parameter which they have considered. So both parameters are there.
Sir, it is not an employment exchange, sir. See, the thing is that the person who has understood the company should continue. See, it is not a providing. It is not an IBC is not a platform to provide employment to people. Actually, the thing is that if the person is if there was a person who has not done any mistake, actually, let him continue. That option you give it to COC. That option you give it to NCLT judge also. But amending the law for everything, actually, that will create issue. See, only thing is that today there is no possibility of any resolution.
I am telling you, this is our perspective. But before making the law, there had been a great conversation with all the major banks in India, with other stakeholders, with other financial creditors, financial institutions, the insolvency professional agencies. And after all those deliberations and the opinion expressed by different stakeholders, the law is framed. So it is our version which we are saying, and that version is equally correct. I am not denying that. Our version is perfectly fit. I understand the company. I have done all the process. If some new person will come, he will face several challenges, several difficulties. Process will get delayed. This is our version. What is their version? This I am telling to you. Their version is that the person who could not complete the liquidation, you are correct, CIRP resolution, then he should not continue as a liquidator. Some new person should come and do it. This is their version. Although we all have objected it. I think several friends are sitting over here. Definitely they would have objected it. We have also objected. Let us see what would be the final outcome, what they prescribe in the final regulation. So in final regulation, the position would be totally clear. This I am talking on the law position only, which they have put in the law. But now in regulation, maybe they may try to cover it up that if the RP failed to do these acts in CIRP, then he cannot be appointed as liquidator. Maybe let us hope the best. We have given suggestions.
Sir, actually, I tell you the problems are actually, see, these type of cases, no, when it goes to see the CRP, we don't get our fees. For various reasons, there are a lot of challenges. I am sure that everyone must be undergoing some problem. That fees is not received for whatever reason. If that RP is changed, actually, it is all the more impossible to chase actually because it is going for some years and years. We lose track and we don't get any of our fees. This way we have lost heavily. Even that other liquidator comes also, even that liquidator sells some pot also, he is taking his fees first. He is not paying the RP's old fees first actually. See, lot of challenges are there. Practically, if you see that, see in my case actually, once it was in CRP, it was removed. Again, it came into CRP. The first fellow did not get the fees. I am also not getting the fees. Now, if the liquidator is going to be a third person, both the other two persons, both IRP and RP will not get the fees.
That is a very peculiar situation because in our several cases, there may be one or two cases wherein the fee application is pending. But in all the 39 cases, even if the new liquidator is there, they have paid the fee because we lodged our claim with evidences. But this is a peculiar situation you are talking about, that the liquidator
That's why I'm
did not
saying,
pay the
see, if
fee
you
and
have a
expenses of RP, and he took his fee and everything. But that is a very, you may refer the matter to the IBBI in that situation.
I will refer it. See, this is, I mean, that is why I'm saying that, sir, if it is the sweeping provision is there, the problem is that the persons who are right actually will get affected. That is the problem actually. That is the problem. I have lost in 2-3 cases actually, because that liquidation. There are so many challenges in the land. It is agriculture, non-agriculture, revenue department, this, that, so many fight. 2-3 years go actually, we don't get anything. Or the liquidator is able to sell, say, out of 5 properties actually, he is able to sell 3. He is taking his fees. The other 2 properties virtually impossible to sell. So what happens is, we also forget actually, because it is going for 2-3 years actually, we forget it.
I understood, sir. So I would request you to connect with me. I will guide you properly into that. Yeah, what is to be done in those situations. But we have already discussed that the CIRP cost non-payment or delayed payment, it has to be addressed by the regulator properly. This we have already discussed. And if it is not addressed, it is a very hardship to the professionals who are working in the system. We are important part in the system. And if our grievances, our problems are not being looked into by the regulator, then it's a very, and it is not so. We have already discussed with the IBBI officials several times this issue. This issue we have discussed several times, a number of times. On 28th also we will also discuss privately, because at stage we will not be getting any time. But definitely we all would be there. So we will again put our grievances. Whatsoever regular meetings they hold, we are there and we pose all these issues which you are telling to me right now.
Sure. Sir, actually, in my case, actually, what happened is all the creditors are operation creditors. There is no financial creditor. So because all are operation creditors are also not contributing. Operation creditor, they say, sir, we have to receive our money. Why I should pay money for RP fees? So operation creditor also not able to pay. Nobody is able to pay. We are unable to sell the land. So that's a big challenge.
Yes. Yes, sir.
We are affected in all 4 sides. We are affected, sir.
That is the problem. That is the problem. So these are the challenges and concerns which we have already discussed quickly. There are only 3 slides. So they have provided 14 days admission, 30 days plan approval, 30 days liquidation order, all mandatory. But NCLT benches are severely understaffed with hundreds of cases pending per bench, mandating timeline without judicial capacity expansion converts a reform into compliance fiction. Delays will still occur. Courts will simply record reasons, defeating the purpose. The purpose shall be defeated, which we have already discussed. Chapter 4A requires a notified class of financial creditor, specified conditions, electronic portal, and extensive IBBI regulations, none of which exist yet. अभी तक कुछ है ही नहीं. The process cannot practically operate on commencement without these foundational elements being in place. premature implementation risk creating a parallel process that is unworkable. Group insolvency, Section 59A gives the central government power to make rules for group insolvency, but does not itself establish any rights or procedure. Without corresponding rules and a clear definition of when proceeding must be consolidated, the provision offers no immediate relief. Large insolvencies like IL and FF type will continue to be handled ad hoc. तो उस पर अभी कुछ है ही नहीं, तो ला बना दिया, वो बना दिया, इस पे तो बहुत काम अभी वी हैव टू डू. We have also positioned that it is a critical, it is high. Legal gaps and potential for litigation. Withdrawal restriction. Amended 12A prohibits withdrawal after the first invitation for resolution plan. While this prevents abuse, it can trap parties in a CIRP even when a settlement is commercially sensible, particularly where the debtor raises fresh funds post-admission. Courts may continue to allow withdrawal under inherent jurisdiction, creating inconsistent outcomes. अब ये मीडियम रिस्क है कि भाई, अब now you are saying कि only after constitution of the COC the withdrawal can be made with 90%. So previously it was not there. License continuity. Section 31(5) prevents suspension of license, permits during resolution. A major investor confidence measure. Investor confidence will be boosted. However, this overrides sector regulators, RBI, SEBI, TRAI, who may have independent statutory grounds for cancellation. Fit and proper criteria. Potential constitutional conflict with Parliament delegated regulatory powers subject to challenge. Now I have done a very great level of violation and RBI or SEBI suspended my license or blocked me for 5 years, 10 years. And someone is resolution applicant. He is saying that it must be restored. Without it, resolution is not possible. So there will be, they are also created by the Parliament Act. So there will be conflict. Restoration of CIRP. COC can apply 66% vote to restore CIRP after plan failures, allowing 120 more days. While valuable, this creates incentive for COC to deliberately run out of the clock, then seek restoration on improved terms. Only once restriction is a safeguard. But the standard for NCLT to grant restoration is undefined. Litigation on this threshold is inevitable. So there must be some framework in the regulation that under which circumstances or conditions NCLT should grant restoration. Otherwise, COC is filing for the restoration of CIRP and corporate debtor is filing objection to it, or some RA is filing objection to it. So if the conditions are not specified, there would be litigation. Dissenting FC's payment, Class BA, Section 32 mandates fair payment to non-voting financial creditor. But in complex capital structure with multiple FC classes, secured, unsecured NCD bonds, computing the correct floor across Section 53(1) waterfall and liquidation value simultaneously could be extremely contentious and invite appeals at every resolution. So इसमें हर उस पर अपील हो जाएगी. Unresolved structural issues and implementation risk. Cross-border framework is still delegated. Section 240 empowers the central government to make cross-border rules, but India has not adopted unilateral model law. Without concrete rules, foreign creditors have no certainty. Implementation gap could span years. तो ये तो सेक्शन डाल दिया है. Only section is there, except that nothing is there. Voluntary liquidation. Termination of voluntary liquidation requires 2/3 creditors by value to approve within 7 days. For companies with dispersed creditors, this window is neither impossible, the provision may remain only on paper. COC oversight. COC supervisory role in liquidation. Risk creditor influence in asset sale. Without clear supervision versus direction boundaries, liquidators face conflicting instructions and liability. It should be properly defined. Guarantor asset transfer, where multiple creditors have security over the same guarantor asset. 66% inter-creditor agreement is required. In practice, valuation, dispute, and conflicting security agreements may render this workable. What is there? We are having a CIRP, and PIRP provision is PIRP is initiated against the director. Now, with the approval of that PIRP creditor, that guarantor will be transferred to me, to the CIRP. RP will handle this, and it will be merged in that CIRP. So this is the transfer provision, guarantor asset transfer, which they have given in detail in the regulation. So this is the challenge. Information utility authentication gap. Operational creditor must submit IU record before Section 9 filing. But CRISIL IU coverage is partial. Disputes over valid IU records may delay admission, inverting the reform's intent. तो रिफॉर्म से कोई फायदा होना नहीं है. If IU has recorded something, they will file appeal to the Honorable High Court. Enclave High Court, COC conduct standard, participation risk. IBBI can now set conduct standard for the COC member under Section 196 ASA, imposing liability on institutional creditors with separate fiduciary duties may deter active COC participation, creating indecisive committees. तो जब तक ये नहीं होगा तो COC functioning has to be improved. Related to payment, related to decision, they take extension 3-4 times. And we are mandated to file the resolution plan before 15 days of the closure of the CIRP. They take 1 month time to decide on the resolution plan. These are the challenges. There must be a specific guideline for the COC also. So friends, with this, my presentation is over. Now it's over to you all for having mutual discussion over the several aspects. So
I have a question,
open
sir.
to our sweet friends who
I have a question,
deliberate over the issues.
Yes. I have a question, sir, on voluntary liquidation. What do they mean by termination of voluntary liquidations requires 2/3 creditors by value? Initially, when the voluntary liquidation started, such kind of resolution is already approved for voluntary liquidation. Then why termination after this? I'm not able to understand why they have put in this.
Actually, what was there, that if I filed a voluntary liquidation application, okay, so previously there was no provision that I may withdraw that application. There was no provision. If I filed application, then the process has to be completed. Now they have provided that in case we want to withdraw, or you may say termination of voluntary liquidation, then it may be done by 2/3 of creditors passing resolution, a special resolution in such a case. So in the meantime, it is there that I may enter some arrangement with the creditors or some OTS, one-time settlement with the creditors, and they are agree, but my voluntary liquidation is going on. So now what can I do? I cannot do anything. So that's why they have incorporated this provision.
Okay, sir, but I got it. But voluntary liquidation for the creditors, they are to be paid initially. Only after that, the voluntary liquidation can come to an end. But now for withdrawal they have put in this one. This is what you mean to say, no?
So we will have to see the regulation in detail for that purpose. Let the regulation be notified.
Okay, thank you.
Sir, I have a doubt, sir.
Yes, sir. Yes, sir.
Regarding the disciplinary proceedings on the resolution professional, getting a new assignment, the adjudicating authority check for the disciplinary proceeding. And when you made the presentation, you told that the disciplinary proceedings is the proceedings considered when a show cause notice is issued.
Correct. Correct.
So, but I would request all the three IPAs to recommend to IBBI that until the final order is being issued by the DC, it should not be considered as a disciplinary proceeding, because show cause notice tomorrow after investigation, if it proves that there is no fault on the resolution professional, there may be a big drawback on the resolution. He would lose a lot of assignments. He would lose many things. He would have got a bad name. So until a final order is being passed by the DC, it should not be considered as a disciplinary proceeding. This is my suggestion, which the IPA, all the IPS have to take it up with the IBBI.
Totally valid suggestion, sir. I do agree with your suggestions in totality.
This is a very critical situation, because tomorrow if this continues, tomorrow we will see all the resolution going out of this carrier itself. Tomorrow it will be a big danger mark. So this is to be taken up very seriously in the next 10-year celebration or the conference which is going to happen in the Hyderabad. Or this is a very important category which needs to be considered. Okay, this is one thing. This is one thing, sir. The second thing, which the section 33 CRP restoration, that is 120 days, which you mentioned in the presentation.
Yes.
Is it going to be 180 plus 90 and 330 extra, or it is going to be included in that 180 and 270 90 days?
No. When they will order for the restoration of CIRP, from that order date, the process has to be completed within 120 days.
Okay.
The previous period will not be taken into account.
I agree this point, sir. The objective of the IBC is to resolve the matters of CD in time-bound manner.
Correct.
And maximization of credit to all the stakeholders. That is the objective of the IBC code itself.
Correct.
So when you made a presentation, you had just indicated that even if I get a better resolution, I can go for an extension of CRP. That I have a slight difference opinion, because once a evaluation matrix and request for resolution professional and everything is given and the time frame is completed, a new resolution applicant cannot come inside. That CRP extension can happen when it is a liquidation process. But improving the resolution plan may not, because it is never ending. Tomorrow will come.
No, sir. What is there that they have prescribed for the liquidation. They in the law they have not used the word resolution. This has been used by me. They have used the word liquidation, that you have filed application for the liquidation.
Then it is fine, sir. Then it's fine.
You have filed application for no. I am coming to my point also, that you have filed the application for liquidation, and then you are approached by some resolution applicant, and then you applied that no CIRP should be backed. What is my interpretation to this? Because there has been a number of litigations, and I have also countered two cases in my case to help the banks. So what I presume, this is my presumption, this is not law. This is my presumption. What I presume, that even if you have filed application for the approval of resolution plan, and in that scenario, if you are having something extraordinary with you, so with this provision you may apply. They have not used it. This is my presumption.
Okay.
Because previously what was happening, there was nothing in the law. So they were straightway dismissing it. No, you did not join the UI process, that process, and that process, so you cannot come directly into it. So when a person who did not participate in the CIRP process and application is pending for liquidation, how he can join now? So if he can join, the new person may also join. As regards a new person may also join, this is my interpretation, my presumption.
Okay.
They have not said in the law.
Okay.
They have simply said if application of liquidation is filed.
And the last point which I wanted to bring it is that information utility recording in the Section 9 application by the operation creditor. Actually, I have a slight difference, because before sending a demand notice, in case I record it in my information utility, and when the information utility sends it to the debtor, and if it disputes it, it falls under a pre-existing dispute when the application is filed.
Yes, yes, correct.
So what in fact, I have even submitted a research paper on the 5th International Conference on the same subject. What I recommend is, you issue a demand notice, let the demand notice be served on the debtors, everything. Before filing the application, you file the IU data, so that it will not fall under the pre-existing dispute, because your demand notice has been served. And your criteria of information utility recording also is satisfied before filing the application.
That is there, sir. When we deliberated on the regulation on 24th and 25th, 2 days consecutively, that this was a major issue which was forced by us, that in case, because the dispute will not be resolved by the NCLT, and they will consider if operational creditor is filing, definitely the corporate debtor will dispute it. It's a different. 90% in 90% cases they will dispute it, and that dispute record I will enclose with my Section 9 application, so where my application will survive. And whenever I will try to justify to the learned A, they will say that I am not concerned with it. I am not here to resolve whether your dispute is wrong or dispute is correct or whatsoever, go to the civil court. So that we have given a strong suggestion in lines with your recommendation. We have already given.
After demand notice, recording is okay. That is acceptable.
That is correct. Fully correct. Yes. We have already done it.
Thank you very much.
And I think that our ICSI officers should be sitting. They must also be noting all the valid concerns which our members are raising. Overall, we all are working for the betterment of the system, whether it is IPA, we, and IBBI. Everyone is oriented to that. So we are giving in-hand practical, shop floor experiences. Yes. And that should be considered.
Yes, sir.
Yes, sir. I do.
And the last point which I wanted to raise, sir, one of our friends also raised the interim moratorium in the PG cases. When a section 90, when the section 94 and 95 application is filed, automatically an interim moratorium is being started. But as per the new amendment, the resolution professional have to file an application to the adjudicating authority to commence the moratorium. That is what the amendment says.
Correct.
So that means automatically the section 96 is becoming invalid, because the interim moratorium is not at all valid once the application is being filed.
Correct.
We have a great chance when in a section 94 or 95 application is filed, and when a section order is being passed, right, before that, if the PG sells his asset and if it is unsecured, then we will be losing the asset because there is no interim moratorium on that one. So that was the reason why I thought the interim moratorium was built in, so that the PG will not act on any selling of the assets.
No, sir. If a PG is selling, the personal guarantor is selling or transferring assets, then now we are having the provision that we may apply and the learned will issue orders. So that is there. But this interim moratorium situation, it is for the creditors who are going to enforce the SARFAESI action or any other action. This is for them. If the PG is doing any act, that you may enforce always.
Okay. That is not for the debtor. Not for the debtor.
That is?
If I am correct, it is not for the debtor. It is only for the creditor, the financial creditor.
One minute. Yes, sir. Now every friend is visible properly.
Anyhow, sir,
what are you telling, sir?
No. The SARFAESI proceedings, the financial creditor we can proceed, but the debtor cannot sell the asset. The PG cannot sell the asset after the application is being filed.
Yes. And if it is done, you may invoke it. Now the provision has been inserted. Okay. You may invoke, get it back to your.
And when are these regulations expected, sir, for this amendments, regulations?
Regulation has also been amended, and even now you see that the PG asset will be transferred to the CIRP.
No, I am talking about this amendments, April 2026. These regulations, when it is being released, sir?
When regulation is going to be released?
Yes, sir.
We presume on 28th.
28th?
28th May.
Okay.
It is our presumption because IBBI is celebrating its 10 years. So from that, on that occasion, they may enforce certain provisions.
Okay.
Different sets of provisions shall be implemented from the different dates.
Okay. Anyhow, sir, thank you very much for your very good presentation. And it will be grateful if you can share the presentation so that we all can get the slides, so that we'll have a recap.
Definitely, sir. We always share. Previously, also we have shared. We will share to the institute, and definitely they will be forwarding it to you. The entire PPT we will share it to you.
Thank you very much, sir. Thank you.
Thank you, sir. Thank you.
Thank you, sir, for your wonderful presentation.
There, sir. Thank you, Sandeep.
Thank you, sir.
Contact details,
Thank
sir.
you.
Sir, your contact details.
Thank you very much.
Yes, sir. Yes. Please tell.
Your contact details only.
Contact details.
Your contact details.
Contact details. Acha, okay. So you
Chat
note
box
down my
में.
number if you chat box में डाल दें. I am giving it in chat box, sir.
Yeah.
You got it, sir?
Yeah. Sir, you are a VIP, sir. Fancy
Yes, sir,
number you have.
again.
Fancy number you have, actually.
Thank you, sir. It's I would be awaiting. Please come on 28th. We will meet there. I think most of the friends will join that event.
Sir, how do you register for that event, sir? 28th event. How do you register?
IPS have sent mail IBBI has also sent mail to the IPs.
Hello.
They have sent mail, sir. कहाँ कर रहा है ये? भारतीय मंडपम.
Okay.
Bharat Mandapam. They are organizing. Bharat Mandapam. Otherwise, if you have not received invitation, you may request to your IPA. They will manage.
Okay, sir.
My sweet friend Sandeep Goyal ji is present. So many friends are there.
Bhatt ji is
Today I
always a
am
good
fortunate to
orator.
have such
Yeah.
a experienced, knowledgeable, and lovely friends.
No, it's our privilege to listen to you, sir. You are very good explainer.
Thank
It
you,
was
sir.
a wonderful session.
Thank you, sir. Thank you, sir.
Welcome, sir. Welcome.
So, should we close now? The
Yes, sir.
IPA officer, please complete the proceeding, today's proceeding.
Thank you very much, sir. The session was very knowledgeable and very wonderful. Your thoughts were very wonderful, sir. You are requested to kindly share the presentation
Yes, sir.
so that
Yes, ma'am. We
the
will
next
share you
session.
PPT. Kindly share it to our friends.
Yes, sir. I will send it to the party.
Thank you. Thank you very much. Thank you, my sweet friends. Have a wonderful evening today. Thank you.
Thank you very much, sir. Thank you.